625. Rogers v. Mont Hill LLC. 422. Movimiento Missionario versus Sobro Development. 625. Excuse me. First Trinity versus Advanced Funding. 525. Dobco Inc. versus the City of New York. Submitted. People v. Darian Bailey. 515. U.S. Bank v. Zoo is submitted. O'Brien v. Kaplan is submitted. First case for argument is Tedford's Tenancy versus the City of New York. Yes, you may proceed.
May it please the court, Your Honor. My name is Gregory Burns, counsel for Plaintiff Appellant Tedford's Tenancy, LLC. Appellant's appeal from a pre-answer motion to dismiss on a regulatory takings claim. Plaintiffs, or appellant here, is a small landlord. They own a six residential unit, one commercial unit building in Gramercy Park. The 6 residential units here are subject to rents, which are...
Counsel, why isn't this case premature? Because since your clients didn't pursue their administrative options.
Yes, Your Honor. The case is not premature because the appellants have articulated in their complaint as well as in their opposition here that even if any remedies were provided by the administrative agency here, DHCR, they would be futile in this case.
Isn't that purely speculative? They don't know what DHCR would do.
That is incorrect, Your Honor. The rent stabilization regulations provide for a 6% increase max. That is the most that could be given by DHCR in the event of a rent. We plead that even if that 6%...
That's an annual increase, correct?
Correct, Your Honor. We present that 6% would still result in a regulatory taking under the circumstances. I refer to Nick v. Town of Scott. The U.S. Supreme Court struck down the exhaustion requirement, and later on in Appellate v. City and State of City and County of San Francisco, later also modified the finality requirement that.
But did that really strike down the exhaustion requirement? I mean, there's certainly a lot of Second Circuit cases that do not go your way, that say before you're going to have some kind of regulatory takings claim as ripe, you first have to go through the steps that you must go through to make the application for, in this case, a DHCR hardship application.
So what Nick held was that the state governments cannot interfere with a 5th through the 14th Amendment regulatory taking and say that it comes ripe immediately upon the taking. Now, and that is through exhaustion. Now, in regards to the finality requirement, the court in Appellate v. City and County of San Francisco, the Supreme Court also held that the finality of a taking is a much softer standard, and we only need to know what their position would be. Being that the regulations already attribute the max remedy provided, DHCR doesn't have any discretion to deviate from that or provide any additional remedy beyond that.
Counsel, how do you square other Second Circuit cases that have found that application for hardship has to be done first before this type of issue can be entertained?
Though, under those circumstances, the primary argument was that the process is complicated, and we do assert that here. But we're also saying that the final results do not reach that end. They do not reach a remedy for the taking that has occurred. If you give all the benefit that you are allowed under the circumstances here, and we did the math and put it into our complaint of what that math would be.
Is that math speculative, though?
No, Your Honor, because we know what the rent roll currently is. We know what the legal rent roll would be. to calculate under in this case, the rent stabilization code. The rent stabilization specifically provides for the 6%. There's nothing in that code that provides for anything that is greater or beyond that. So you are limited, or DHCR would be limited to granting that.
What about the calculations of your expenses? Because doesn't that come into play in terms of like how much revenue that you're able to make, even given any increases?
Yes, Your Honor. But however, we're even giving the benefit of the doubt to the government that they would give us the 6% here. We're not saying that the 6% will not, we're not saying that they could give us less. We're saying even if you give us the 6%, which is the max they can give under law, then our rent roll would only increase by a minimal amount. As for the expenses themselves, this is a pre-answer motion to dismiss. I believe those should be left for discovery here and kicked for a later date.
Strategically, why didn't you make those applications for a hardship increase and then seek the type of relief that you're seeking here?
Well, part of the
Because you had to know that you were going to face the questions that you're facing today.
Yes, Your Honor. The reason that we held off on not filing an application, one, it is very burdensome and it is time consuming to go through. But I understand that is not alone enough to do it, but the result would be hundreds of dollars onto a rent roll with a building that's losing $40,000 per year. The makeup and time to go through that process, get the 6% increase, and then eventually be able to bring this application would take years upon years. Meanwhile, this building is suffering today. And it's our opinion that the regulatory taking has already occurred. The only question is, what is the extent of that regulatory taking, not that it has not occurred already.
Thank you. You have time of rebuttal.
May it please the court, Stephen Yanni for the state respondents. First, on the question of ripeness, plaintiffs' claims are unripe because they never applied for a hardship exemption. And the Second Circuit has repeatedly rejected regulatory takings claims in the same posture for this exact reason, because without knowing whether a landlord is entitled to a hardship increase or what that increase might be, it's impossible to determine what the regulations.
You heard, go ahead.
How do you answer their argument that under the best of circumstances, it would be an increase of 6%, which wouldn't even begin to meet their needs?
So I think that my opponent's argument is based on a misunderstanding of how the calculation works. So it's true that each year the rent can only be increased by 6%, but a 6% increase is available on an annual basis until the total awarded amount is
He
achieved.
needs a lot of years of those increases to get anywhere near his problems.
Well, I think two responses to that. So first, just to finish up on what the hardship increase could be, it takes a look at the income versus expenses and ensures that the landlord can achieve at least income that's at least 5% above what the expenses are. But I think another critical problem here is that the expenses and income are also entirely speculative. Half of plaintiffs' annual expenses are comprised of property taxes, and there's still an ongoing tax certiorari proceeding, so we don't even know what plaintiffs' annual expenses are at this point, nor have any of the major improvements that plaintiff alleges are necessary been undertaken yet.
So if they did an MCI, if they did a major capital improvement, or they did an individual apartment improvement, whatever that's called, would that be in addition to the 6%, on top of the 6%?
That's a separate process, so it would depend, I guess, on whether they qualify for the hardship exemption, but it goes through a separate process. My understanding is that a major capital.
What's the maximum he could get per year?
I think that it depends on what the income and expenses are. If all of the requirements are
percentage-wise, isn't there a ceiling on it?
What the hardship exemption does is ensures that the annual income exceeds expenses by 5%. Then the MCI covers up to a certain amount, and that's applied 2% annually over year. So
Does that mean he could get a 30% increase in rent from one year to the next?
No, it wouldn't be a 30% increase in 1 year to the next.
There's no 6% cap on this?
There'd be plus any other additional increases they were able to get from MCI or IAI increases. But I think the point is that really it's impossible to tell at this point how the regulation is going to affect them economically because we don't know.
But to go for an MCI or an IAI means they've got to put a lot of money into the building, which they're already losing money on.
But isn't that what they're saying, that they're planning on making renovations and that's what's making their expenses burdensome? Aren't they already arguing that they're planning on putting some money into the building?
They are, but the problem is none of this has been undertaken. In fact, they allege that only a superficial inspection of the structure of the building has been done. So we don't really even have a concrete idea of what these expenses will cost or when they will be incurred. I mean, there are allegations in the
If they were going
complaint.
to undertake those kinds of expenses, wouldn't they get increases under the DHCR rules?
Yes, at that point, they could apply for these increases that we've been talking about. And I think the core problem is they haven't gone through all of these steps. And under the Second Circuit's recent decisions, and even under the Supreme Court's decision in Yee v. City of Escondido, it's not enough to say that it's burdensome in the abstract to go through these procedures. You have to run the gauntlet of the available statutory procedures before you can bring a regulatory takings claim or an as-applied takings claim. And just to turn to the merits for a moment, the complaint here does not come close to alleging a regulatory takings claim, and there's a few problems. First, it does not allege a categorical taking, which requires a total loss or a complete elimination in value. On the face of the complaint, the plaintiff has been collecting rent for more than 40, plaintiff and his predecessors collected rent for more than 40 years from a ground lessee without issue. It continues to collect rent from commercial tenants and the residential tenants, and there's no allegations in the complaint about how the regulations have impacted the actual value of the property or what the sale value of the property might be. And without that central information, they can't state a takings claim under either theory.
Thank you.
May it, may it please the court, Tahir Sadria appearing on behalf of the municipal respondents.
So can you address the issue as to the MCI?
I can't state what the specific limitations on an MCI are. I mean, my understanding is that, I mean, it's as my colleagues stated, it's a separate process, and it would be something that would be in addition to the. Assuming that there was that they qualified, it would be in addition to the hardship exemption. There are limits on the amount of it, but I think that there is so much speculation in this record right now. I mean, that to say that it is futile is, I think, is there's not a record basis for that, because you have a situation where like the rents, I mean, the plaintiff is not even certain what the legal rents are. I mean, and so it seems like we would need to determine that, and then whether they could obtain like the increases, and then whether, you know, how much are the, and how much are their actual expenses. I mean, under what's set forth in the complaint, the rents, including the commercial rent, as actually received, it exceeds the operating expenses. I mean, then they have not by a huge amount, but I think it's the kind of thing where, you know, if they were able to obtain increases of hardship increases and these sorts of things, that could make the property viable as the rental process, as a rental property. And as my colleague also indicated, a good portion of these expenses, like such as the taxes, are a subject of litigation and could well change. The amount that is, I think that also it's like the repair costs that they're talking about are not attributable. While they're alleging that there are substantial repair costs, these are not due to the rent stabilization law. This is due to the fact that they haven't been repairing or
Right, deferred
upgrading the buildings.
maintenance. I think they're suing the prior ground lessee in a separate action. I believe that's.
Yes, and that, I mean, and that they could, I mean, that could affect like what their expenses are as well. I mean, again, it's like if you have a house and you don't take care of it for a number of years, and then, you know, you have to replace the roof. I mean, that's not because of any kind of.
But would all of these issues have been fleshed out if they had proceeded in the administrative route in terms of the monies for the rents, the repairs? All of these things would have been fleshed out during the administrative proceedings?
Certainly how much the rents they would be able to collect would be fleshed out. I mean, it seems
And also
like,
the sale, the value of the property.
and yes, I mean, these are all issues that could be, in these various proceedings, could be fleshed out so that there could be a determination on actual fact. And again, as my colleague said, on the merits, there is just not a claim here. Plaintiff, in order to establish a takings claims, needs to establish what it was the value of the property, what is the value of the property now under regulation, and there is nothing on that. Thank you.
So, counsel, I wanted to be clear, when you took over this building, it was subject to rent stabilization, was it not?
Well, Your Honor, my client's parents bought the building in 1940 prior to any rent regulation, or at least rent stabilization.
Right, but when they took it over for purposes of, I think,
They inherited it.
vacant, and then when they took it over, it was subject to rent stabilization, right?
Yes, Your Honor. They inherited it in 2006, and it's our position that in Palazzo, the Supreme Court made it a flexible standard on what the time frame is for determining when you took possession of the property, and they're to take in all different factors. In that case, the Supreme Court stated that just because you purchased after the regulation doesn't mean that you do not have a claim for that regulation, and it's our position, and we have now found any case law to support one way or the other in the Second Circuit or the First Department or the Supreme Court, the issue of inheritance and what that time frame would be. It was my position that it's a fact, or our position that is a factual issue that should be determined through further discovery here. I believe the court said something to the extent of you're supposed to take in all the
So
factors.
what would the further discovery be? And why would that not have been accomplished if you had pursued the administrative route?
So further discovery would include intent of the parties. What was the intent of my client's parents from when they passed, or from before when they passed away, and also when they took over the position of the property? If the intent was to
How would you
purchase,
get that from the opposing party? How is that discoverable from the opposing party?
it's not necessarily the opposing party, but third party as well. It would also be through further investigation through my clients of going back and dealing with their family, or the family history there. And because we are talking about a period that's not
They
yesterday,
have a
but
family history. They can go back. You could have gone back before you started this action.
well, Your Honor,
So wait, are you claiming that you should not be subject to the rent stabilization laws? Is that a claim?
well, the claim is that we are entitled to compensation for it, and to the extent that there is no compensation, we should not be subject to it.
Thank you. Thank you all. Hassan versus New York City Civil Service Commission. Yes, you may proceed.
Good afternoon. May it please the court, Antonia Koussoulas for the appellant petitioner in this matter. My client was terminated after a disciplinary hearing held in his absence. He had called out sick. The police department
So he
approved.
was made aware of the fact that there was going to be this proceeding. Is that correct?
That is correct. There's
And
no,
this isn't the first proceeding for which he called out sick for, right?
well, he was injured in July. He had longstanding
Okay,
injuries.
but it's not the first
Well, it-
proceeding on this issue for which he called out sick.
It's the first one where he called out sick because the previous time this matter was on, he had given advance notice that there was a 2-week period.
Well, he gave advance notice after the dates were already set, right? So there were dates set for this proceeding, and once those dates were set, then he obtained a doctor's note indicating that he would not come in, right? That he couldn't come in because he was sick.
He, on the first time, I believed he notified the tribunal in advance that he needed to take 2 weeks off. The second time, he notified the police department, his command, on the day of the hearing.
So the day of the hearing was conducted in his absence. He did not appear, obviously, on that
He
day.
did not appear.
The date prior to that, when the hearing date was set, he was informed of the hearing date. He was also informed of the fact that if he did not appear on that hearing date, that the hearing would be held in his absence.
Well, there's a dispute about that, because the only evidence that was presented to the tribunal, I don't believe a notice was presented to the tribunal about what the consequences would be for his failure to.
I thought it was that it was indicated that they would be proceeding in his absence if he failed to appear.
I believe that was during a conference. He wasn't present. The union attorney was present.
At this point,
Go ahead.
at this point, we're reviewing a Civil Service Commission determination, right?
That's right.
So aren't the only issues that you can raise that there's been a deprivation of a constitutional right? And you did not raise that before the Civil Service Commission.
Well, we're raising it because it implicates serious constitutional rights, including the fact that his attorney.
But you can't come to the appellate division and raise that claim. Do you not need to preserve that claim in front of the Civil Service Commission? And you didn't. It didn't bother you at that point how this had transpired.
There's two issues, and if I could address that. The first one is on whether there was a constitutional waiver of his right to be present. That issue we submit was raised
Constitutional waiver of what? I'm sorry.
for his right to be present at the hearing and present evidence at the disciplinary hearing. The police department never said that that doesn't apply to him. In fact, their brief is replete with, in their argument, that my client was entitled to those rights.
But the question before you is that before the Civil Service Commission, did you raise this issue of a constitutional violation based on the fact that he was not present at the hearing?
Well, I didn't, but the union attorney that represented him did on that issue, and we submit that
The issue is preserved?
the issue is preserved on the record. I know the city's taking the
Well,
position
you were
it's not
told, he
preserved.
was told that if he's not present, the hearing's going to go forward anyhow, that the hearing will take place in absentia. Wasn't he told that on August 18th, and wasn't that repeated to him by the Assistant Commissioner Kleiman?
On November 30th.
Right.
He wasn't present November 30th.
But his attorney was present.
His
on those.
attorney, that's the problem here. The same attorney that represented him then shows up to the hearing date, claims that he was discharged a week before, never once moved to withdraw as counsel, never once tried to protect or not prejudice my client's rights. And on the day of, after he moved to withdraw, claiming he was,
He was present on August 18th, wasn't he?
I believe,
When he was told that if he's not present, the hearing's going to go forward anyhow.
I don't know if there's a record of that on the 18th.
Well, you talk about the attorney showing up and stating that he had been discharged. He was the third attorney that your client discharged.
There was a union attorney initially. He went out and got a private attorney.
And then
Then he realized he couldn't afford the private attorney.
Right.
Went back to his union. The union.
And then he
gave him this
discharged
attorney.
him. And this same attorney who came in on the date of the hearing, who stated that your client had discharged him, then apparently a couple weeks later, your client re-engages him.
I don't believe he re-engaged him. There's a question about that, and that's one of the issues. Here's the
Well, that, again, the issues that we are to review, are the constitutional issues that were not preserved during the hearing. Those are the only issues we can.
If we look at the record and what was presented to the Civil Service Commission, the fact that it was clear that there was no finding that there was a constitutional waiver of his right to be present here. In fact, the officer, the trial commissioner, found that the basis for the waiver was that he had discharged his attorneys. That had never been a reason as to why any case was adjourned, ever.
I don't recall that, but you have time on rebuttal. Thank you.
Thank you.
May it please the court, Janet Zalian for the CSC. Supreme Court properly held that the petition states no cause of action for what needed to be shown here, which would be a statutory or legal basis to review the CSC's decision.
Your adversary indicates that this constitutional issue was preserved. Is there anything in the record that you can point to suggest that that's?
Yes, it was not preserved. The reason is that the attorney, Mr. Lichten, who prepared the appeal to the CSC, did argue that it was unfair to hold the hearing in absentia. Now, this court pointed out in the Almansar case that we've cited that there has to have been some constitutional claim presented for it to be reviewed in this court. Now, the NYPD argued that he had a constitutional right, that it was waived to attend the hearing, but he had waived it. Actually, what we pointed out in the brief is that according to the Court of Appeals Gordon against Brown case, actually that confrontation right to attend the hearing applies in a criminal case. So that actually isn't even accurate. But even assuming that the NYPD had somehow preserved a constitutional issue for Mr. Hassan before the CSC, he did not take advantage of that. He did not request permission to or try to submit any further briefing to the CSC to say, yes, I agree with this. He did not request a hearing, which under the rules.
Was he represented by counsel at this time? Because there was some.
Yes, he was. He was represented by Mr. Licton.
So, but at some point, Mr. Licton, I thought on the day of the actual hearing, came in and stated that he had been discharged.
He had been discharged. As far as he knew, he had been discharged. However, since he represented Mr. Hassan on the appeal to the CSC, it appears that Mr. Hassan went back to the union and requested counsel again, and Mr. Licton again represented him on the appeal to the CSC. So he was not without counsel at that time. He was represented by counsel before the CSC, and he could have requested a hearing on a matter that hadn't been raised in the record below. He could have said, no, I object that I have a constitutional right and I didn't waive it. And also the other constitutional rights that are alleged here, such as the right to counsel, which again is based in the Sixth Amendment and only applies in criminal cases. But all the other constitutional claims that are being made in the petition here were all unpreserved before the CSC. May I ask the court if you have any questions? Thank you, Your Honors. We'll rest on a brief and ask to affirm.
Thank you.
If I may, on the preservation issue, we submit that the issue of whether there was a valid constitutional waiver has been preserved. Mr. Lichtman did raise that issue in the, and I know it's on the record, page 156. And in fact, he cited to Tulas Parashad v. Kelly, which is this court's decision basically dealing with the due process rights of individuals in disciplinary proceedings. Now, he may not have expounded a lot on that, but he did raise it in the argument. With regard to the right to counsel, the rules themselves with regard to these disciplinary proceedings provide for my client to have an attorney represent him at these hearings. And due process does apply here. The evidentiary rules may not.
I have a question about, you referred to page 156 of the argument.
No, 156.
I'm sorry, 156 of the record.
Yes.
There's nothing on that page about constitutional rights.
Well, he says, with the stakes as high as Hassan jobs, the department should have made sure appellant excuse was illegitimate before holding a one-sided hearing. And then he cites the case that deals specifically with a constitutional deprivation in a disciplinary manner. You know, I can only, but we say it was preserved. The other thing that, with regard to his right to counsel, we say it doesn't need to be preserved because there's, I think it's Ahmed, the Court of Appeals has held that if it's clear and irrefutable on the record that there was some kind of constitutional deprivation, this court could address that issue. And here you have the same attorney who walked in on the day of the hearing and said, I was, you know, not, I withdrew a week ago, but made no motion, no notice to my client or anything like that. and then moves to withdraw, and then somehow is the same attorney now presenting this appeal, that should have raised some red flags for the Civil Service Commission as to what was going on here. And
Thank you. Thank you
thank
both.
you.
Skydonic versus ESRT Empire State Building. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Joshua Annenberg, Appellate Counsel for Plaintiff Appellant Skydaniuk. As a matter of law, the lower court erred in denying the plaintiff's motion for summary judgment under Labor Law 240. The plaintiff slipped and fell down the stationary escalator due to three factors. First and foremost,
Yeah,
with
counsel, the
respect-
fact that you did win below on 241 sub 6, right?
That's correct.
And they make your opponents make the point that somehow that's contradictory to also finding that this was a safety device under 240 sub 1.
No, not at all. If I could refer the court to my reply brief, and that's where I discuss this issue, and it's a salient point that what the respondent's brief relies upon is a 1983 case called Ryan against Equities. However, in 2008, I'm sorry, Ryan against Morse Diesel. However, in 2008, this court in Jones v. 414 Equities overruled Ryan. And in Jones, it held the plaintiff can recover under Section 240, even though he was injured as a result of the collapse of a permanent floor. Jones effectively overruled Ryan that held that a permanently installed stairway was only a passageway from one place to another and outside the scope of Labor Law 240. With respect to our argument, it's not an either-or proposition. Quite frankly, it's both. You could have liability under Labor Law 241-6 under the Industrial Code 1.7 E1 and E2, and you can have liability under Labor Law 240. The stationary escalator in this instance was indeed a statutory safety device because it served as the functional equivalent as a permanent stairway or a permanently affixed ladder, and it served as the sole means of access between the two levels of work, the lower level and the upper level. And the plaintiff here slipped and fell down the escalator because of, in the first and foremost in this appeal, the loose masonite treads which slid underneath his foot.
I thought that the reason for his falling, or the claimed reason, was because of the loose duct tape, and that was like a regular tripping hazard.
Well, that's a tripping hazard. However, there is more than one proximate cause of an injury or of an incident, and that's clear from the case of Scurry that was decided by the Court of Appeals about a year ago. It's also clear from this court's decisions that I cite. Specifically, I remember there was a case of Pardo against Bialystoker, this court in 2003, where it held that there are more than one proximate cause in general and specifically of a Labor Law 240 action.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon. My name is Evie Kazansky. I represent the third-party defendant, Denko. Very briefly, the first argument is that there's a contract between us and the owners, and that the plaintiff was our employee. However, the entirety of the situation is that the accident occurred on this escalator due to loose debris that had nothing to do with Denko's work. So to the extent that we're saying that it
I don't know,
didn't-
that's not your strongest argument, I don't
I
think.
know.
counsel.
So I was very briefly just saying
You got it
that
out of the way.
notwithstanding that situation, the bigger argument for us and the bigger concern is the actual dicta of what the judge said with regards to the indemnification clause. She's mixing up construction, insurance procurement, and leases. At this juncture, there is no finding of any actual negligence against DGC, which is the bigger, the GC, because the owner's
You would
already.
not be required to indemnify DGC.
So that's why we're asking for the modification at this time, especially,
But we don't know at this point who's negligent, so.
so specifically, that's why we pointed out at JA 36. And then at JA 37, she's already seemingly made a decision that we owe for all their claims.
So you represent Denko, so why did Supreme Court err in denying your motion for summary judgment as to indemnification? We have to await and find out who was actually negligent here.
Well, that's my point, is to the extent that the way you read it as of right now, if you read this decision, the argument is being made, I'm just asking for a
Yes,
modification,
You
actually.
can't indemnify them for their own negligence, right? But
Yes.
as to who ultimately bears the burden here, we have to see whether it's ESRT, Denko, or DGC that's the negligent.
Understood, so that's why we're asking for the modification to the extent that right now if you read the decision, it says including DGC's.
So you want that stricken from the decision?
Yes, we're asking for the modification at this time, that if you decide that the summary judgment was properly denied, that to the extent that any and all discussion of indemnification should have been stricken from the record because it was our motion, not theirs.
Thank you.
Thank you.
Good afternoon. My name is Paul Golden. I'm representing ESRT and DGC. One of the issues in this case, of course, is how Sky Daniak fell. That is not been resolved, at least in terms of their claim that masonite absolutely, positively, 100% must have caused it. They have not proven that. There's a great deal of evidence indicating that that's not what caused it. One of them being that the plaintiff himself only said it's likely. That's not enough. Plus, the people who put in the masonite specifically indicated, the man who put it in there said that he reapplied it and made sure it was proper every single day.
But then, so that was DCG's employee, right, who stated that he was the one who put the masonite on the escalator. But wasn't there also testimony from, I thought, DCG's representative as well, in looking at the photographs, that you could see that there was issues with the masonite and also with the duct tape?
No, I don't believe that he said there was, I mean, the duct tape we'll leave to the side, but I don't believe that he said that the masonite in and of itself was loose. And I think if you look at the photo, it shows there's no indication of.
It's always a wonder why attorneys put in photographs that are totally, they don't depict anything. It's just like a black blob on the paper. So I'm not understanding what those photographs were supposed to show.
Well,
there are a couple of photographs of the plaintiff, lying prostrate after the incident, which is a great photo. And you see some of the masonite, but otherwise, the photographs really don't tell us that much.
Well, of course, I'm not claiming that we have a close-up of each and every step or anything like that.
Right, and there was testimony, was there not, in the record, that someone observed that there were issues with the masonite?
I believe the only person who testified to that degree was the plaintiff.
Well, there are also color pictures which do show an issue with the duct tape. So why wouldn't ESRT or DGC, as the general contractor, be liable under 241 here?
And why wouldn't they be liable?
Why
under
wouldn't they be?
241?
Yes, under 241.
I don't believe that we've appealed from that part of the decision, Your Honor. We're respondent in this case, and then 241.
Well, the plaintiff has appealed from it, saying that they should get summary judgment on 240 sub 1. 240 sub.
I misheard you.
Okay, so the plaintiff has appealed and says, I should have received summary judgment on 241, and you're opposing that. So what is your reason for saying that there isn't 241 liability here?
For one, is that there is no absolute 100% evidence. A jury needs to hear what the actual cause was, because if it may have just been the debris, and this court.
Well, the plaintiff says or presents evidence that he fell because whether it was debris or the masonite or the duct tape, and the photos back up the duct tape. So why wouldn't that evidence be accepted? What countervailing evidence is there to that?
Especially if we look at the stationary escalator as a stairway, which constituted a safety device for which the plaintiff fell off of.
Well, I have a few comments to that. One is that, of course, is our position that the stairway was not a safety device, especially in this context.
But why wouldn't it be a safety device? I know you would not normally think of a stairway as being a safety device, but here this became the means of going from the basement level to the concourse.
The soul means.
There's also, say,
The soul means there were.
the soul means, well, I want to say, I believe there's two different escalators, one for each way, but leaving that issue to the side, there was no failure of the safety device. Also, this court and the Court of Appeals has indicated that if it's just an ordinary tripping hazard that causes the fall,
I don't
ordinary
understand what you
tripping
mean by
hazard is
saying
not,
there's-
excuse
I
me.
don't understand what you mean by saying there was no failure of the safety device if what happened is that essentially the step came out from under him.
First of all, we don't, that is a disputed issue as to whether the masonite slid. That is a totally disputed issue. But even if it was, our position is that the safety, if we're going to call it a safety device, the safety device itself did not fail. Third, as I put in my papers, there's also the issue about Ryan case from 1983 indicating that as long as it's a passageway, then it cannot be a safety device. They've picked which one they want. You know, they can't have their cake and eat it too. They've already decided, absolutely, this was a passageway, and the case law seems to indicate that as long as you admit that it's a passageway, then you seek relief under 241 subsection
So
6.
if the safety device didn't fail, what explanation do you offer for the fall?
Well, one explanation is that there was debris on the stairway, and the debris on a stairway, slipping on a little bit of refuse, which happens in all workplaces. Nothing is 100% clean. That's not a failure of the safety device. That's just someone left some debris on the property. No one would say, "Oh my gosh, I tripped on a banana peel. I tripped on a piece of rock." Well,
We
that
don't
means
have
the
a
entire
banana peel here. We have duct tape and masonite that is alleged to have been loose on the sole means for which that plaintiff could get to the elevated space of where he was working.
Also, I have to also say that at least as I read your cases, Your Honor, there's a distinction between whether when someone falls on a staircase, were they actually working working on the staircase? Were they actually screwing in something, doing some work, or were they just walking from one place to another? This court seems, especially in the Waldron case, seems to have made a very big distinction between those kind of cases. Is it a case in which someone is just simply walking?
This was in the midst of work. He had gone to get a shield.
When I say working, I mean actually standing there on the staircase, screwing in something, attaching something. That's one thing. That's a bit more dangerous, basically, as opposed to just walking from one place to another. The point of the statute, the original point of the statutes, was that there is the danger when someone's walking, going up a ladder, going on a scaffold. They're in a very dangerous situation, especially when they're working at the time. That's a very, very, very different thing. It's a polar opposite from just a normal person walking downstairs and then they happen to trip on some debris. No one.
That's not what the record indicates we have here. First of all, he stated that he tripped on the masonite and the
Duct tape.
the duct tape. When asked about the debris, he stated he didn't know whether there was any debris. But again, he made it clear that that was not what caused him to fall. And we're back to the point where this is the means, the sole means for him to carry out the functions of his job.
First of all, it's our position is that well, first of all, he said they asked him a question about the pieces of brick, and he said, "You want to know if the pieces of the brick was part of my trip?" I don't know. That was his words, not mine.
He said he fell because of pieces of the concrete, the loose masonite, and the duct tape were together.
Yeah, he also said it was likely. However, we've also got the other testimony indicating that they put it in place every single day. So a jury has to decide what was the exact cause of this.
Thank
It
you.
can't be just decided on paper.
Thank you.
Thank you so much.
Your Honors, with respect to rebuttal, I believe the bench has my argument, and then if there are any questions, I'll be happy to answer, but otherwise, I rest on my brief and my prior argument.
Thank you. Saran TV, Cortland Development. Yes.
May it please the court. Brendan Fitzpatrick, counsel for the appellant, Gold Line Steel. Your Honors, the mere fact that an incident occurred doesn't support an award of summary judgment under Labor Law Section 240. The mere fact that gravity is implicated somehow tangentially to the happening of an accident does not support an award.
Tangentially?
Yes, Your Honor.
What was
That's what the Court of Appeals said in Ross.
Right, but what, in this case, what was tangential about the gravity-related nature of the accident?
Your Honor, I'm just repeating what the Court of Appeals said in Ross against.
Yeah, I know, but I'm just asking you, how are you applying what you're repeating to the facts at hand?
Because gravity applies to everything. It applies to us as we sit here today. And the mere fact that gravity is
The
involved.
question is whether or not gravity acted here. Are you claiming it didn't?
No, gravity always acts, Your Honor. That's the low burden that plaintiffs have in 240 cases. To simply claim that an accident happened and that gravity was involved.
Well,
Apparently-
let's talk about your case, right? Because we're talking about huge beams that were being hoisted with a makeshift type of hoist, right?
No, again, plaintiffs can pejoratively call it a makeshift hoist.
What do you call it?
I call it a pulley, a chain block pulley system where
Was
Mr.
it a
Soto.
pulley system that came from, that was manufactured by somebody, or that was made on the job by people at the job?
It was designed before the job, it was used before the job, and it was used after the job. It was designed, and an engineer looked at it,
Is that
inspected
in
it.
the record?
Yes, I believe pages 1,000 to 103 of the record. Mr. Lorenz, who's a professional engineer, he's the only expert in this case. He looked at the design of Mr. Soto from Gold Line, and he said, yes, this chain block pulley system is sufficient. He went through,
He wasn't the person who designed it,
Mr. Soto?
the person you're quoting. The person you're quoting isn't the person who designed this
He
system.
prepared the draft. Mr. Soto prepared the draft of the schematic drawing of the pulley system.
But
He said that, and then it broke.
The mere fact that it broke, Your Honor,
But let me just finish the thought about the fact that it broke. I mean, the plaintiff is alleging that parts of the pulley system then hit him on the back, and so it was impelled to do so by the big beam it was carrying. So that's not a gravity-related incident?
And again, Your Honor, everything on a construction site, a trip and fall is
Okay,
gravity.
all right, I agree. It has to be a
Getting-
gravity-related incident that 240 sub 1 applies to. Why is it not
There
that?
has to be a violation and there has to be causation, and we don't have either of those here. What we have is plaintiff claiming the accident happened and gravity is related, so therefore it's 240, and it has to be. This isn't a case where, as this court has held on a couple of occasions, where something broke or something collapsed for no apparent reason. We have the apparent reason. We have the reason that Mr. Lorenz attested without debate that this device was sufficient and proper to use for this task.
Don't we have someone, a supervisor, Contreras, who said when he learned of the accident that he called the Department of Buildings to indicate that this was an unsafe type of work?
I don't, simply because you call the Department of Buildings after an accident, I don't believe implies that there's something.
He considered the welding of the base of a pulley system onto a beam to be dangerous. So it wasn't simply a phone call. The reason was because, based upon his experience and his observations, he considered that the welding of the base of the pulley system onto the beam to be dangerous. And we have the testimony from the plaintiff that the reason that apparently the welding gave way because the middle of the three of the first beams detached, and that's what struck him in the back, or that's what struck him.
Yes, and we also have Mr. Soto, Mr. Bermeo, Mr. Lorenz, all saying the exact opposite. They're saying that there was nothing wrong with this pulley system, not a makeshift police
But there
system.
had to be something wrong with the police system if it
Because-
broke. That's what I'm not understanding.
Your Honor, this isn't a case where the police system was only able to lift something around 500 pounds. And plaintiff proved that this weighed 2,000 pounds. This is a police system that could carry 2,000 pounds.
And that was based.
Not because it broke.
No, Your Honor, because plaintiff, and this is the testimony of Mr. Bermeo, Mr. Soto, and Mr. Lorenz, they said plaintiff exerting so much pressure on the welds, that caused the failure.
He did that at the direction of one of his supervisors.
No, he did that at the direction, according to at least plaintiff, because plaintiff said he only took direction from Mr. Bermeo. That's his testimony.
Even if he did that, does that not rise to the level of some sort of comparative fault versus proximate sole cause of his own accident?
Your Honor, I think that at the very least, it's a question of fact for a jury to determine. A jury to determine whether you have an expert saying that this police system was completely appropriate for this task. And they had used it in the past, and they had used it in the future, and without ever an incident. And the only difference in this case is plaintiff continuing to exert pressure, and that caused the welds to break.
Thank you.
Good afternoon, Your Honors. Renton Prasad for Appellants Cortland Development and AB Capstone. May it please the court. The lower court erred in finding a question of fact regarding whether Goal Line is negligent as to my client's contractual indemnification claims. First, case law says, and it's clear they're not required to show,
The plaintiff was your employee, is that correct?
No, Your Honor, plaintiff was Goal Line's employee.
Oh, I'm sorry, I thought you said you represented Go Line. Apologies.
No. There's no requirement that we prove that Goal Line was negligent. In a case like this, where the only basis for my clients to be liable is through a statutory violation, there's no requirement that we prove that Goal Line was negligent. And even if we were required to prove that Goal Line is negligent, based on the facts of this case, as between my client and Goal Line, there can only be one party that would be negligent. That would be Goal Line. They fabricated the hoist, they transported it to the site, they installed it, and they controlled its use. Additionally, the court decision is inconsistent as to the finding that there's a Labor Law 240 violation, but then finding that there's a question of fact as to whether Goal Line is negligent. If there's a question of fact as to Goal Line's negligence, and it's the only party that controlled the hoist, made it, then there can't be a Labor Law 240 violation, and vice versa. And the anti-subrogation rule does not apply here. This is a case where it's not been established that Goal Line's insurer was covering Goal Line and my clients for the same risks under the same policy. In their tender response,
When you want to impose contractual indemnification on Gold Lion, right?
Correct, Judge.
So that indemnification provision provides, provided that same are caused in whole or part by the willful misconduct, recklessness, bad faith, or negligent acts or omissions of the subcontractor. So how do you get a determination? How do you get summary judgment for indemnification until it's established that Gold Lion was either reckless, acted in bad faith, or negligently?
Judge, if, as the lower court held, there is a Labor Law 240 violation, then only one party can be negligent, that's Goal Line. And in that case, we are entitled to contractual indemnification from Goal Line.
Why is there only one party that could be, but who says that Gold Lion is the one that's negligent?
Judge, Goal Line fabricated the hoist, they transported it to the site, they installed it, they controlled its use. There are no other questions.
Where does AB Capstone, right? That's the general contractor, right?
Correct, Judge.
Where do they fit into this? When you say that Gold Line is the only one that could be negligent?
There's no evidence that they had anything to do with the hoist, Judge. All this
Right,
testimony.
but they're the GC on the job.
Right, their only liability here would be statutory under 240, but the actual actions that would constitute the purported 240 violation would be by Gold
I don't know how you
Lion.
get summary judgment on indemnification where your entitlement to it is dependent upon showing that the indemnitor is negligent, and we haven't had such a finding yet.
You're
Judge,
basically saying that if there's a 240 sub 1, correct me if I'm wrong, but you're saying that if there's a 240 sub 1 finding of liability, that necessarily that means that the actor who provided the safety device was negligent? That's what you're saying?
in this case, Judge, yes.
I don't know if there's a case that says that, though, counsel. I mean, you have a case that says that? Because you know, there are two different theories of liability. Negligence has certain elements, and 240 sub 1 has other elements. And so I don't know if you can make a predicate that way.
241 doesn't require showing negligence.
Yeah.
I understand, Judge, but as to the indemnification clause, we would still, if Gold Lion, their actions were the cause of the violation, then they owe us contractual
Right, but
indemnification.
the optimal part of what you just said is if, and we don't have an answer to that if yet.
Correct, Judge, but if, based on the lower court finding that there was a violation, then if that upheld, then we're entitled to contractual indemnification.
But not at this time? Because we don't know.
I mean, if the court were to reverse that, then yes, there would be no
I
contractual
don't know that it would
indemnification at that
require
time.
reversal, but thank you.
Thank you, Judge.
Good afternoon, Your Honors. May it please the court, Kenneth Gorman for the plaintiff respondent. This is a classic Labor Law 241 violation. The pulley system failed because it couldn't withstand the stress of lifting a beam that weighed several thousand pounds.
Well, they said they have an expert that says that this pulley system was appropriate for the work it was being used for.
Could have been appropriate for the work, but it wasn't safe. It wasn't the safety device that was required for the work. It could have, I mean, the fact that it was able to lift the beams is one thing. The fact that it collapsed and the pulley system fell on plaintiff's neck.
Well, because the plaintiff was using it incorrectly.
Excessive pulling.
Right.
That's what they say, but I mean, it's uncontested that Mr. Bermeo, who testified that the plaintiff was excessively pulling it, he also testified that Mr. Budalo, the plaintiff's supervisor or foreman, was instructing him to keep on pulling it.
How would the excessive pulling play into the proximate sole cause of the accident in any event?
It doesn't. I don't think it does. The bottom line is that it failed. It was too heavy. It wasn't sufficient for the job at hand. And with regard to the
What are
expert,
we talking about in terms of the pounds of the beams?
several thousand pounds from what I understand. And I'd just like to refer the court to Zimmer versus
And the
Chim.
several thousand pounds fell on the plaintiff's neck, right?
It was either that or the pulley system that fell on the plaintiff's neck. I think several thousand pounds would have killed him.
And is it your position that this pulley system was makeshift?
It was makeshift. I mean, they made it on the job. It wasn't manufactured by a company. It wasn't on the market. They didn't sell to the public. It was manufactured on the job. The fact that an engineer signed off on it doesn't mean it's sufficient, especially since it broke. I mean, the bottom line is that it broke. The plaintiff isn't responsible for determining the exact cause of the accident, but just want to point out that Jamie Contarina's Capstone supervisor testified at pages 440 to 441 of the record that the pulley system failed because it could not hold the weight of the beam. It was insufficient. This is a clear case of clear violation of Labor Law 241, and the plaintiff was properly granted summary judgment. If there's any further questions, I'll rest on my brief. Thank you.
So at this point, all defendants, owners, and general contractors are now guarantors. According to plaintiff, all he has to prove is that the accident happened. That's something, according to him,
Excuse
failed.
me, are you claiming that any of us said that?
No, I'm claiming that plaintiff said that. Plaintiff is claiming that because he says this failed, even though the defendants have presented, or at least my client has presented evidence that not only was it appropriate, but that it didn't fail and that it had been successfully used before and it had been successfully used after to not only hold this, but according to Mr. Bermeo, twice the weight of this. But according to plaintiff, all they have to show is that this failed and fell, therefore they get summary judgment.
Well, did it fall?
It fell. There's no debate that it fell, Your
Well,
Honor.
it failed.
It did not, Your Honor. Why did it fail? What was the cause? We have grounds to say that it fell and it was caused to fall because of plaintiff's misuse.
What was the evidence presented that the plaintiff misused it, one, and that two, that his alleged misuse led to to it failing?
Mr. Bermeo testified that his instruction to plaintiff was to hold it in the air so they could actually weld it to the bottom of the ramp. According to Mr. Bermeo, he kept exerting pressure. And according to Mr. Bermeo, and as well as Mr. Soto, and as well as Mr. Lorenz, the professional engineer, they said that force caused the welds to break. Plaintiff may not like it. Plaintiff may now.
So your expert says that the continuing pulling by the plaintiff caused this to fail. Based on what?
He tested because of the excess pressure caused by the pulling that caused this to fail. Now, plaintiff came before you and said this beam weighed several thousand pounds. According to plaintiff,
My question was, I'm sorry, I'm looking at the expert's report, your expert's report. Where in the report specifically does he talk about the amount of pulling that can be sustained by the hoist, et cetera?
he testified that this beam or this pulley system was sufficient to hold up to 2,000 pounds. According to Mr. Lorenz.
Where does he say in his report that excessive pulling would somehow detract from its ability to hold up to 2,000 pounds?
I believe page 1002 to 1003 of the record, he said that there was, that the excessive force caused by plaintiff pulling on it caused the incident, not any failure of the device, which was appropriate for the task.
Thank you.
Thank you.
I think everybody can leave on this case. Brownie Companies versus Volmar Construction. Yes.
Good afternoon, Your Honors, and may it please the court. Christopher Bletch for the appellant of Volmar Construction. I wanted to first point out that this case is an unusual situation in that there's a companion matter, excuse me, where Volmar is litigating with the city of New York for the monies that are withheld. So Volmar is not taking the position that these liquidated damages are improper. We're contesting them. But the primary position that Volmar is taking is that to the extent that the city has threatened, or in this case now has in fact withheld liquidated damages from Volmar's contract balance, and it's related to the Brownie scope of work, that Volmar is entitled to also withhold that money from
The point is, we don't know whether or not the the city's holding back of those funds is related to the work done by Brownie.
Right, and at a minimum, Volmar has presented evidence first that of the 75 homes that Brownie invoiced for that it claims it was unpaid on, the expert report of the city identified 70 of those homes as having liquidated damages, which totaled over $9 million. If you recall, Brownie's
That's the Taylor spreadsheet?
The Taylor spreadsheet was different. That was
Okay.
that was the Arcadis expert report. The Taylor spreadsheet dealt with the issue of the analysis of the Volmar invoices for elevation and lift work, and that concluded that all of those invoices totaled a certain amount of money. There wasn't underlying evidence of the Volmar invoices that was based on, nor did it have records of the payments that were made against those invoices. And importantly for the Taylor spreadsheet, even if it's accurate, it still shows that $914,000 was being withheld as against those invoices.
Don't you make the point that it was prepared for litigation and therefore it's hearsay?
Absolutely, yes. So we don't think it should be considered, but even if it were considered, it doesn't support Brownie's case because the withholdings shown there are in excess of the amount of the Brownie claim. I think the two errors that the court made below are important to point out, saying that the Volmar Brownie subcontract did not have a liquidated damages clause. We point out in the two places where it very clearly does. It's the record 1227 and 1229. There's a clause that says if Brownie's work is late, that Volmar is entitled to withhold $500 a day for liquidated damages, which mirrors the city Volmar contract clause. And there's a separate clause on page 1229 of the record that says, to the extent that money is withheld by the city against Volmar, and it's determined that those withholdings were attributed to Brownie's scope of work, that Volmar can also withhold that money. That's what was done in this case. The court seemed to assume that Volmar was paid all of this money and withheld it from Brownie. The record contradicts that. There was no evidence of what was paid to Volmar. In fact, Volmar is out over $27 million compared to the 474 of the Brownie claim. So far in excess of the Brownie claim, and within that $27 million would be the amount that's sought by Brownie. But since the city is still holding it from Volmar, it was not proper to find summary judgment. Importantly, Brownie didn't meet its burden to show that it was not responsible for any liquidated damages, and as the move on a summary judgment motion, it was required to do that. No delay analysis to show that its work wasn't late. It was a conclusory affidavit.
Also, your contract with the city did not require the city to specify which subcontractor had held things up.
That's right. So the city made the point that their contract was with Volmar, so they didn't in their report or their withholding say we're withholding this amount of money for this particular subcontractor. But on the motion to renew, once we had actual itemization of what the withholdings were for, we put in an affidavit from the Volmar principal that explained that $5.6 million of monies that were now actualized and the liquidated damages withholdings that were actualized related to the Brownie scope of work. So we feel like that at least creates a question of fact as to what percent of the withholdings Brownie is responsible for. If you recall, they were the lift and the elevation contractors. So they were lifting these homes. They were responsible for designing that work, performing that work, excavating and doing the foundation work. So they were a large contractor responsible for a significant portion of the work. So we believe that the evidence would show that that if the city prevails on its delay and liquidated damages claims against Volmar, that at trial we would show that Brownie is responsible for a significant portion of that, and that at a minimum creates a question of fact which should have precluded summary judgment.
Thank you.
Thank you.
If it pleases the court, Anthony Batista from Condon and Forsyth on behalf of Brownie. So we have three contracts here. We have the contract between Volmar and Brownie, which says there's going to be payment within 7 days. It also incorporates...
Within 7 days of their receipt of the relevant funds from the city.
Correct. It also has in the agreement a 5% retainage clause, which says that Volmar is allowed to retain 5% of the proceeds for 90 days. And during that 90 days, there has to be a final inspection. What we did is we took the deposition of the COO of the city.
What happens, you did the work, and Volmar puts into the city to get paid. Some of the things they pay, some of the things they don't pay. But at the end, the city says, well, you know, there are issues with some of this work that's been done, and it turns out that work was done by Brownie. What's Volmar's remedy for that? And the reason I ask that, because you have this affidavit put in by Peter J. Volandis in opposition to your motion, or in support of their motion, on page 1151 of the record, which says, meaning that the city has and is currently withholding or refusing to pay Volmar a total of $914,084.71, just in connection with the incomplete subset of invoices listed in NICEF docket number 81. I assume that relates to work done by Brownie. So how do you account for that?
Brownie only did about 1/3 of the work. Brownie was paid $7.1 million for the project, okay? And they're owed $475. For the foundation and lift scope of the work, Volmar was paid $21.7 million. And that's in the record at page 910. That's based on the testimony of Robert Taylor from the city. So Volmar's scope is this big, whereas Brownie's scope is this big. We weren't paid for what we did. We're only a 10-person firm.
Holding up some of that money, based on issues, lateness, whatever, I don't understand how that bears on in your argument, what you just said.
Well, what does bear on the argument is the city of New York came to our oral argument and made an open admission in court that they are not blaming Brownie for any of the liquidated damages. And Judge Ostrager put that in his decision expressly. It's a party admission made in open court by the city of New York.
They may have an admission, but no money, right? They need the money to be paid by the city, regardless of that admission, in order to then pay you.
No, the city of New York, which is claiming liquidated damages against Volmar, says none of those liquidated damages are the responsibility of Brownie.
I understand that.
I'm sorry.
So you're stating that it's clear and there's no further determination that has to be made as to whether or not the city paid Volmar for the work that was done by Browning?
Absolutely. And the evidence is clear. It's testimony of Lou Mendez, the COO of the HRO for the city, by Robert Taylor, who was in charge of auditing for the city. These people were disposed. They were subject to
So the
cross-examination.
$914,000 that is being withheld, according to Volandes, relating to invoices listed in NICEF document number 81. Which invoices are those?
In document number 81,
Yeah.
Mr. Volandes, that's the first time on summary judgment that it's ever been raised that there were any issues with any of the invoices. That's several years after the invoices were issued. There's not a single email. There's not a single piece of paper. There's
But
no...
aren't they saying, look, we haven't been paid by the city, and some of that non-payment relates to your work?
Well, that's the testimony of Mr. Volandes, which was unsupported by any documentation. The testimony of the city of New York is that Volmar received $21 million for payment of the foundation and lift. Brownie was
And what's the total amount of the contract that was to be paid? They received $21 million, and how much was at stake altogether? They didn't get every last penny, I'm sure.
I only know the numbers for foundation and lift.
But again, it still, that doesn't, it begs the question as to whether or not Volmar was paid for the work done by Browning.
They were. That's the testimony, the undisputed evidence by Robert Taylor and by Lou Menendez, who's the CEO of the city, said that they couldn't move forward on the project unless that first phase, the lift and foundation, was paid and inspected. They couldn't go any further, and they paid it.
Thank you.
Briefly, I think it's important to mention in reply.
So your, excuse me, your friend says that the record is clear based upon the statements by the city or arguments, and which Judge Ostrager included in his decision, that the city paid you for all of the work done by Browning.
That is demonstrably untrue. We cite in the affidavit in reply that once we got the itemized withholdings, there were $5.6 million of liquidated damages withholdings that were directly attributable to the Brownie homes.
How do we know that those withholdings were directly attributable to the Brownie homes? What indication in the record suggests that?
There's the Volandes affidavit, and there's a spreadsheet attached to it which itemized the homes on which Brownie
Right, so
worked.
how is that credible as opposed to the testimony of a representative from the city itself?
It's a good question, and the issue that what Mr. Mendez testified was that they did not do a delay analysis early in the work. So payments would be made in the early part of the project to keep the work going, whether the work was delayed or not. They didn't do a delay analysis until the end of the home. So whether Brownie was late or not, those payments were going to flow regardless. And the fact that the payments were made early in the project has no bearing.
He says the city has conceded that they have no claims as to Brownie's work.
That's because
true?
that's only true to the extent that they made the point that their contract was with Volmar, so they didn't differentiate in their liquidated. That's different.
That's different. Your friend states that they conceded that they have no claims as to the work done by Browning, not that they cannot assert any claims as to the work done by Browning because their contract was with you.
I don't think that's an accurate reflection of what the record says. The only point that the city made on liquidated damages was in the context of a settlement discussion, which was included on the record. They offered to waive the liquidated damages on the Browning homes, but ultimately, as we saw from the withholdings that were issued, they withheld liquidated damages nonetheless.
Thank you.
Thank you.
Mount Haven v. Rothermel. You guys were getting along so well in the audience, talking during the proceedings. I didn't know that you were adversaries. You seemed like such friends with those numerous conversations. You may proceed.
Short to be that aggressive with each other. Okay. May it please the court, good afternoon. My name is Keith Corso, attorney for the appellants in this matter. It really has to be emphasized at the outset that in this very unusual, unique Article 78 proceeding
So
below,
have you read Janet Transit, Inc., the Mount Haven Improvement Group, which was from October 10, 2024? By this court.
Yes,
You
Your
happen
Honor.
to glance at that decision?
Yes, Your Honor. I was retained as, Abrams Fesserman was retained as counsel only recently, only in connection with the reply. I did become aware of that.
And
opinion
so
after the reply.
how does that, and I think I know the answer, but I'd like to hear your answer. How does that bode with this appeal?
Well,
with the issues presented in this appeal?
Well, Your Honor, I think that if I have the opinion you're talking about correctly, is that that's the preliminary.
231 AD 3rd 516, decided by this court on October 10, 2024. Is that correct, Justice Michael? Because I believe you were on that panel. Oh, good. Thank you.
And that was the appeal to vacate the preliminary injunction. Denial
Yes,
of preliminary injunction.
Yes.
Your Honor, that addressed only one part of this appeal. That only addressed the jurisdictional argument with respect to CPLR 5015. That is one aspect of our arguments here, but I think that.
So what case says that you can challenge a confession of judgment via an Article 78 proceeding?
Well, I don't know why, I can't speak to why Mott Haven decided to try to effectively amend the judgments of confession by filing the Article 78 proceeding. But that was their third bite at the apple to do so without notice to the appellants, who were the ones who gave the confession to B&B Bank. And unfortunately,
Claiming that they were trying to amend the confessions of judgment, weren't they trying to direct the clerk to accept them?
Well, effectively amend. Originally, Mott Haven attempted.
I don't know what you mean by effectively. They weren't asking for a modification of the confessions of judgment, were they?
Their petition, that's not how it ended up. Their petitions did request that, but as it ended up, the court allowed them to file under their own name the confessions of judgment, which are captioned in B&B's name. And our contention is that we were entitled to notice and an opportunity to present our case in that Article 78 proceeding, but we were not notified of that we were not served with process, we weren't notified with that.
How are you an interested person in that matter?
Because in this Article 78 proceeding, part of the evidence of why we're interested parties are evidenced by the petition's allegations themselves. In the petition's allegations, they claimed that our clients defaulted under a loan. They claimed that the loans and the confessions of judgment were assigned from Dime Bank to Mott Haven. And they sort of and the petition omitted our contention that there existed a forbearance agreement. All of those factual and sort of mixed questions of fact and law about loan defaults and assignments were the basis for the court issuing the judgment that granted the Article 78 petition. All of those issues are actually being contested in other cases currently right now. And in particular, the judgments resulting from the Article 78 actually refer to Mott Haven as the assignee. This is a judgment now. So we feel like that now we have a judgment that states a legal status of Mott Haven, which is a very legal status. We're contesting an entirely different proceeding against Mott Haven. And Mott Haven was aware of this, but we never had an opportunity to address that.
Did Mott Haven sign joint affidavits of confession?
Did Did Mott Haven sign them?
Yes.
No, Mott Haven didn't sign the affidavits of confession. The affidavits of confession were signed by the appellants. But they were signed in favor of B&B Bank. But the very right for Mott Haven to present the judgments of confession, to do something which the Bronx clerk already said they couldn't do, they did it without notifying us. So at the very start, the clerk says, no, you cannot do this. They file a new action in the name of B&B Bank, but we end up vacating that action. And now their third bite at the apple, they file this Article 78 proceeding. And I frankly can't discern from the petition what ministerial duty the clerk failed to perform that was enjoined by law. I can't figure that out, but we weren't even given an opportunity to find out, to oppose it and to
And the clerk
argue
didn't
that he
oppose
could
it
do
either,
so.
right?
I'm sorry, Your Honor?
And the clerk of Bronx County didn't oppose it either.
He didn't oppose it. It was defaulted. The order was issued on default the day after return date. I do not know why he didn't oppose it, but I
Does
do
it
also
imply
know-
acquiescence that, that there's no problem with these, we just need to figure out who the assigner is?
I think that we could take a number of guesses. There's nothing in the record where the Bronx County clerk is stating why they did or didn't default, but that raises actually the more an important question of why wasn't the Attorney General served? The entire one of the purposes of the Attorney General.
But
is
you don't
so
have
that-
standing to, I don't think you have standing to make that argument. That's the Attorney General's argument to make, and they have not made that.
You have time on rebuttal.
Yeah,
Thank you.
We can talk about it more then.
Good afternoon, Your Honors, and may it please the Court, Karina Straub on behalf of the respondent Mott Haven Improvement Group. As this court has already pointed out, this matter has been brought before this court and decided on the very same questions that are now before the court. The court's order stated that the plaintiff's rights under the joint affidavits were not affected by the November 29th order, and that the plaintiffs in that action, appellants here, also do not have any authority to raise claims on behalf of the New York State Attorney General. Those are the only issues that were argued below. Those were the only issues that were raised in the appellant's opening brief, and those are the only issues that are still before this court, who's already decided them. Appellants are not interested persons. Their rights under the affidavits of confession have not changed. The only thing that changed is the name of the plaintiff in the caption, which was expressly permitted in the definition of plaintiff in paragraph 2 of each of the confessions. Paragraph 2 specifically said B&B Bank and its successors or assigns. So thus, when they executed the affidavits of confession, they understood that these loans might be assigned to a third party and that these affidavits of confession might then be enforced by a third party. They had waived all of their rights to notice. They're not necessary to a determination on whether or not the clerk properly or improperly rejected the applications for judgment under CPLR 3218, and they were not necessary to be notified, and there was no error below because of that. I welcome the court's questions.
Thank you.
Your Honors, very briefly, the issue with the Attorney General and the jurisdiction and the standing to raise arguments, that was addressed in that court's opinion, but the court's opinion did not address whether we were or were not interested parties under Article 7802. That decision does not address that whatsoever. And unfortunately,
It does. Plaintiffs contend that they are interested persons and therefore have standing to seek vacator, and states you're not. None of the statutory grounds for vacator are applicable here.
right, but these weren't, but that wasn't made in the context of the Article 78 proceeding. That was made in an entirely different proceeding. And as a result of the Article 78 proceeding, we now have a judgment that is referring to us as, referring to Mott Haven as an assignee. And that status, that legal status, is being challenged currently in other litigations. So we think that we should have been afforded a
But it
right to
certainly
challenge that finding.
alleges that it's an assignee. So it's appropriate that it's referred to that way.
Well, Your Honor, we have several causes of action in the, I guess I'll call it the main action, where we're seeking to invalidate the transfer of a loan, for example, on the grounds of champerty. And so in that case, were we to prevail on that, they would not be the successor in interest or assignee of the loan. It would have been an invalid transfer. And for that reason, we think that we should have been afforded an opportunity to present that in the Article 78 proceeding.
Thank you.
Thank you, Your Honor.
People be anonymous.
Good afternoon, Your Honors. Jan Hoth for Appellant. For over 3 years and at great personal risk, Appellant provided fruitful cooperation. His efforts resulted in several arrests, convictions, and the removal of a lot of drugs from the street.
A part of the agreement that he made was to not be arrested on any new matters, right?
That's correct, Your Honor.
That didn't happen here, though, right?
No. After about 39 months, he was arrested for assault. He did
A violent assault.
Yes, a violent assault. But on the other hand,
That caused serious injuries to the complaining witness, right?
yes, it did. But however, if you look at the assault should have been considered separately from the cooperation agreement. This man lived for over 3
I
years.
don't understand why it should be considered separately. If one of the, if it violated one of the terms of the cooperation agreement, why shouldn't they be considered together?
Because he didn't violate it in terms of, he didn't steal drugs, he didn't lie about his connections, it wasn't
He brutally
related.
assaulted another individual.
Yes, he did.
That's what I'm not understanding.
And he was tried for that, and he was sentenced.
Okay, so
for that.
let's assume therefore that we do consider it separately. He received 8 years on the drug conviction and 10 years consecutive on the assault.
And the 8 years was the minimum
Right.
for what he pled guilty to.
But that's the very point, Your Honor. Where is the benefit out of this cooperation agreement? He pled to
8
the
years.
only count.
The 8
only
years.
count-
He received 8 years,
he
which was the
received
minimum on the drug case.
But he received those 8 years because the prosecutor refused to acknowledge 3 years of fruitful cooperation.
So he should have so there should have been something worked out where he would get 3 years credit and receive 5 years?
Well, the actual agreement called for a replead, and
Well,
since
the actual agreement called for, within the discretion of the prosecutor, what would ultimately occur.
Yes, but that discretion's not unbridled. Defendants are supposed to be treated fairly and in good faith. And here you allowed him to, and I mean the prosecutor, not the court, allowed him to stay on the streets, raise his family, and risk his life day in and day out. And he did it successfully.
So you're asking us to exercise our interest of justice abilities and reduce the sentence?
What I'm asking is that he should have been allowed to vacate the plea and replead to the 8-2 and get the 4 years.
Based on what? Based on what?
3 years of successful cooperation.
And is there any case law or anything that states that that would be proper?
Well, what's improper about finding that the prosecutor's refusal to agree to that was an abuse of discretion? Yes, the prosecutor has a discretion, but it's not unbridled. And then when you couple...
Right, but that's the question that we're confronted with, is that was what occurred within the realm of the prosecutor's discretion.
Yes, and what I'm saying is that by holding him to the A1 felony with the minimum of 8, that was wiping out, acting like it hadn't happened.
So you disagree with the use of the prosecutor's discretion?
Absolutely.
And you're arguing that we can therefore override, I guess, the prosecutor's discretion.
Absolutely.
And so the prosecutor made a determination based upon the information that was imparted by your client over that 3-year period of time, as well as the viciousness of this assault, and made a determination that they were not, that the plea was going to be to the criminal possession of controlled substance in the first degree with 8 years. And you're saying that based upon that somehow was an abuse of discretion by the prosecutor.
The prosecutor did not base that decision on anything my client had done over the prior 3 years. They agreed.
And how do we know that?
Because they agreed that his cooperation over those 3 years
And that's why
was
they
fruitful.
recommended the minimum sentence on that. And the fact is that he violated the cooperation agreement. It's true he did 3 years of service for the people, but at the end, he didn't keep the cooperation agreement.
Well, then I think we need to turn to the question of excessive sentence, because my client now is doing 18 years.
Okay, so we'll address that on your rebuttal. Thank you. Yes.
Good afternoon, Your Honors, and may it please the court. Julia Gorski for the people. The defendant's
Pick up on
cooperation.
the last point, on the assault, the people asked for 20 years, right?
That's correct. In recognition of the fact that defendant was lucky to not have been charged with murder. The doctor testified at
Attempted
trial.
murder.
Attempted murder. At trial, the doctor testified that had he not received prompt medical assistance, he would have died from either blood loss or asphyxiation from the blood pouring down his throat as a result of the defendant literally slashing half of his face off. With respect to the cooperation, it is not to the extent that the defendant presents it as. The defendant entered this agreement in June of 2013. Based on the prosecutor's sentencing memo, he did not make any cases or seizures until the fall of 2015. So while the defense is presenting this as 3.5 years of diligent, hard, useful information, it really only supports about 9 months of productive cooperation. That ended in defendant being...
But he was still risking his life, right? You concede that.
That's true, yes.
Okay.
But
and that was a risk he was taking for 3 years because he was arrested with someone else, right?
Correct. But that was part of the agreement that he signed up for, which also included not committing any other crimes. By committing this assault, he made himself completely useless to the Special Narcotics Prosecutor for any
Let's
further
talk
work.
about the excessive sentence portion again, because your adversary is essentially saying that he received 18 years and that's excessive. But the truth is he received 8 years, which was the minimum for what he pled guilty to, and then he received 10 years after his after the trial, and he was found guilty. And 10 years was not the maximum that he faced, right?
That's correct.
And those sentences were run consecutively because there was no mitigation to run them concurrently.
That's correct. And the mitigation had to relate specifically to the manner in which the defendant committed the assault. So traditional sentencing factors can't be considered. Courts look to whether or not the person was injured, whether or not the defendant displayed a use of a weapon, both of which happened here. So there was just no good reason for the court to run his sentences concurrently.
So he was convicted of the assault one. What was the max on the assault one?
I believe it was 22 years. And the minimum is 5. So the 10 years on that, given the gruesome injury that he inflicted, was wholly appropriate. Just quickly, defendant's challenge to the court's waiver colloquy is unpreserved, and there's no reason for this court to reach it in the interest of justice. Neither Peque or Suazo created new rules for jury waiver colloquies, and waiving your right to a jury trial generally does not result in a criminal conviction. So it doesn't make it any more or less likely that the defendant will be deported. And unless your honors have any other...
What could the defendant have expected had he adhered to the cooperation agreement?
So if he had,
if he didn't commit the assault.
If he didn't commit the assault, it would be based on the level of information and the results that he obtained.
It's still up to the prosecutor, right?
That's correct, yes.
But he would have been able to replete, and it would have been 4 years, right?
That's correct, but the agreement specifically stated that if you commit another crime, and again, this is all in the prosecutor's discretion, but with this specific type of crime and this injury, there was no way that the repleader was going to stay on the table. And if your honors have no further questions, I rest on the brief. Thank you.
My adversary's argument makes clear my client was sentenced to 8 years on the drug case because of the assault.
Counsel, do you want to talk about the legal sufficiency of the evidence portion of your argument?
Well, I could talk about the lack of intent because I think that goes to mitigation in terms of the
He
sentencing.
ran after the guy. He ran after the, you're saying intent? He ran after the victim.
Yes, he did, Your Honor. This is a man who'd lived for over 3 years under a cooperation agreement while driving a livery cab. I don't even pretend to understand the level of stress that that would induce. They started it, they threw a bottle at his car. I think we all...
I watched the video. I think we all watched the
I
video.
think we've all watched the video, so we know...
Counsel, it was a water bottle, and your client got out of his car. He could have kept driving because he was in a vehicle. He got out of his car, and he pursued the individuals. One who you can see clearly from the video looked severely inebriated.
I'm not disagreeing. I think we've all watched the video. I think we all agree on the facts. He didn't get out of the car and immediately attack.
He also got out the car with this makeshift spatula or whatever.
Well, I think it was a spatula.
Well,
but he
most
also,
spatulas ones that I use in my kitchen are not serrated and
I know mine
sharpened.
don't look
I
like,
don't have sharpened spatulas.
yes, mine don't look like that either.
I don't know what you.
But we don't know that it was sharpened.
We do. We do, don't we?
Well, it was in his car. But the point is, he also got out of that cab with a knife. He didn't say, I'm going to kill you, I'm going to F you up, I'm going to do this. He didn't stab him with a knife. He was swinging around a spatula.
Took off half his face.
A
sharpened spatula.
which had an
I am not
astonishing
trying
effect.
to mitigate.
Well, see, that's the
end
other
result.
issue. That's the other issue, though. You talked about excessive sentence. So, what would have been the mitigation to allow a concurrent sentence?
What I'm saying is that it wasn't intentional. The swinging, I mean, yes, he hurt him and he hurt him badly, but it's not the same as taking a knife and stabbing somebody in the heart. He was swinging around a spatula for what I don't want to get into. I don't want to speculate, but the point being, could have found mitigating circumstances. What I'm saying is that when you look at this as a whole, he was sentenced to 8 years on the drug crime because of the assault. And then he was sentenced to 10 years on the assault. Whether that's an appropriate sentence for the assault, I wish we
I
could...
think that I would put it, he was sentenced to 8 years on the drug case because of the assault. He was sentenced to 8 years on the drug case because after the assault, the district attorney wasn't going to allow him to withdraw his plea. That's really what happened.
And
Because
well, as my adversary
how horrible
just
the crime
argued, it
was,
the
how horrible
nature of
the assault was. The assault was so bad that whatever sympathy the DA may have had for him on the drug case, they weren't going to exercise it.
So it's a sentence that was dictated by the assault.
It was a sentence that was dictated by his inability to hold up his bargain of the cooperation agreement.
By sustaining an arrest. Thank you. Anthem LLC versus Nick and Duke. Yes, you may proceed.
Good afternoon, and may it please the court. My name is Ilan Dobbs of Katsky Korens for Auten LLC. My partner, Adrian Koch, was supposed to argue the case today. She had a medical emergency yesterday, and I'm here sort of at the last minute with apologies. Auten sought summary judgment as to liability on two claims, its claim for repudiation and its claim for the breach of the covenant of quiet enjoyment. There's a third damage claim that was at issue. Auten didn't move on it, the landlord did. The Supreme Court granted.
There's a claim that relates to Article 33, right?
Well, so the part of her analysis related to Article 3309, and so she granted landlord's motion for summary judgment on that claim as barred by 33.09, which we believe violated the law of the case and also was incorrect as a matter of law, but it was holding as a matter of law.
But let's assume that you can seek relief under 3309 because of the sole remedy provision. What are you left with in terms of what you can pursue in the case in terms of damages?
Well, the Court of Appeals considered and rejected the argument that was made by landlord that Section 3309 barred our recovery of damages.
Let's put that aside. Let's assume that you cannot, that 3309 bars you seeking money damages.
On which claim, Your Honor?
On the cause of action premised on 3309. To the extent you're claiming money damages based on 3309, let's assume that you cannot get damages for that. What does that leave you in the case?
Well, it leaves us with our claim for repudiation of the lease, which is a claim for damages that the Court of Appeals said is alive, and it leaves us with breach of the covenant of quiet enjoyment, which is also a claim.
Can you get money damages for that latter claim? I'm sorry, counsel. Couldn't you get money damages for breach of the quiet?
Yes, of course.
Okay.
Yes, of course we can. And the landlord argued at length in the Court of Appeals that there was Section 3309 barred our recovery of money damages on the quiet enjoyment claim and on the repudiation claim, and that was rejected. Went through that chapter and verse in our brief. So we have live damage claims on the repudiation claim and on the quiet enjoyment.
The Court of Appeals also said that that claim was not preserved and therefore didn't rule on it.
It didn't rule on the separate, there are three claims. One we call the 2015 PCA claim, which is to say that in 2015, when the landlord refused to sign the version of the cure agreement that was presented to it, that refusal was improper, and we're seeking money damages for that. There's a second claim for repudiation of the lease based solely on landlord's June 2021 letter, where it wrote to HPD and said, we're never going to sign any version of a cure agreement. That act repudiated the lease.
Right, the first claim that you just spoke of, the damages that you're allowed, or isn't that just injunctive relief?
No, we don't think that it is. We think that this court held that the allegations in the complaint, if proven of bad faith and misconduct, vitiate the protections of 3309. On appeal to the Court of Appeals for the first time, they argued, which is not the argument that they made before this court, that actually the governing law is 60 putback, the standard that was announced by the Court of Appeals in the 60 putback case, which made it a little more difficult, raised the bar to vitiate the protections of an exclusive remedy provision. The Court of Appeals said that's not before us, and it affirmed this court's holding that our allegations were sufficient to set forth that bad faith, to vitiate the protections of 3309. The Supreme Court went ahead and said, now I can apply 60 putback. We believe that that's not true. We believe the law of the case, and we've talked about this in our brief, is as affirmed by the Court of Appeals, and that it was not up to Supreme Court to rely on 60 putback because the circumstances under which that would be allowed would be a change in fact or a change in law, and 60 putback was the law when landlord moved to dismiss, and there was no change in the law. It just didn't rely on the case. But we also have made clear that 60 putback does not allow allegations of gross negligence to vitiate an exclusive remedy provision, but our allegations are of intentional misconduct, and the courts that have considered 60 putback have said, these are this type of intentional misconduct, intentional torts, conduct that straddles the line between contract and tort can move forward. But I really want to get back to the lower court's failure to grant us summary judgment on our repudiation claim and on the quiet enjoyment claim, because that's really, those are our principal claims in the case. And she found that issues of fact precluded that judgment, and that was simply a failure to look at the evidence that was presented and look at what was not laid bare in opposition.
The repudiation here that you're claiming leaves no question of fact is really the letter, right? And what's contained in the letter regarding that they will and will not and will never sign any version.
That's correct. And so there is case law we cited on page 24 of our brief that says that when a repudiation is in writing, it can be determined as a matter of law that that was repudiation. In opposition, landlord just simply says, no, we meant something different in the letter than what it says in black and white. And
now, the other part of repudiation, though, is what? That it has to be before the time for performance has arrived, right?
But let's look at the state of affairs here. The state of affairs.
I'm saying you're saying, and you're just making the
yes,
argument.
The time for performance had not arrived because there was no document before the landlord for it to sign. What its repudiation was saying, in the future, we're never going to sign an agreement. We're not going to. I mean,
there was a document, right? Wasn't there a...
There was an agreement that was tendered in 2015. They refused to sign it. This court previously held and was overturned by the Court of Appeals that this was a continuation of the previous conduct. Justice Gesmer was one of the dissenting justices whose position was adopted by the Court of Appeals.
We're aware.
And so the point is that this was superseding conduct. This is a new and different breach, and it rests entirely on that. And so the issue of whether the time for performance is not relevant, and the case law on which that's based is contracts with a fixed date for performance, after which there's a breach. This contract doesn't have that. This contract imposes an ongoing obligation to cooperate in helping to effectuate this cure agreement.
You have time on rebuttal. Thank you.
Good afternoon. My name is Tajinder Bains. I'm the attorney for the respondent, Nick and Duke. I've heard a lot here about the anticipatory repudiation. There was
anticipatory when the letter clearly states that you will not and will never approve any version of a PCA because no cure is warranted.
Judge,
and it says any version, so it's not even saying this particular version because you have concerns, right?
Judge, I believe it says under these circumstances, and those circumstances were really what was at issue for Judge Krause in Supreme Court. The history of this case is that in this lease, Nick and Duke gave...
So under these circumstances qualifies the you will never sign any version.
Under the circumstances of that letter, and here's what the...
So you're saying that under these circumstances meant that if the circumstances changed, meaning if there was some type of a cure, then you would possibly approve?
Yes, Judge, and the facts here
and the circumstances are really the 4 apartments that were carved out of the affordable 14,000 square feet, right, or 15,000.
That's one of them. The second factual issue is there's 4 determinations in civil court that Ordathon, after the lease, were found to have harassed 4 rent-stabilized tenants. They illegally locked them out. The tenants went to court and were restored to possession, and there was a finding of harassment. Now, our problem was that here you have a harassment finding from 2012. You're asking for that to be cured. While you're negotiating with HPD for the cure, you engage in the same conduct that the prior prime tenant engaged in. We wanted to make sure HPD knew about it. There was no fraud. If we had signed...
But simply advising them of it versus putting in language that you will not and will never sign any version of a PCA.
Judge, I understand that language is there, but there's a lot. This is a 2-page letter. There's a lot more there. It says, this is the problem. We will not engage in fraud.
So where in the letter does it say under the circumstances?
Judge, I don't have the letter in front of me, but I believe it says it. I had read it this morning.
I have the letter in front of me. I can't find it, and I don't think it says it.
I don't see it.
I mean, I think it was said by one of the lawyers from your office at some point, but I don't think it actually appears in the, I'm quite sure it doesn't actually appear in the
Judge,
letter.
then I apologize, but the letter does state what the issues are here.
It says owner has no desire to engage in further gamesmanship and will not be a part of what might be considered to be fraud. And then the remaining is underlined for emphasis. Owner will not and will never approve any version of a PCA because no cure is warranted in light of adjudicated harassment of tenants.
And Judge, that is the problem right there. You have a second adjudication of harassment, and this letter doesn't deal with it. But Judge, I would also say the remedy for this would have been an order to show cause brought to compel them to sign a proper cure agreement, which is the sole remedy.
The problem with that is that you say in the letter that you will not sign any version of a PCA.
Judge, I may not sign any version, but if a court orders me and tells me, hey, look, that's what the lease says.
Yeah, but why wouldn't the other party look at that as a repudiation, as an anticipatory breach, if you're saying that you're not going to sign any version of a PCA?
I don't think that the entire letter says they would not sign any version.
But that's the underlined portion, right?
I understand that, Judge. But if a proper cure agreement, which takes into account the 4 new violations.
But as to that, Supreme Court said there's not going to be any money damages.
Correct, Judge.
Okay, so, but as to your repudiation and any other violation of the lease, I mean, why isn't that a subject for trial, whether they're damages or not, money damages for the tenant?
I don't think that there should be any money damages because of Clause 3309 of the lease.
Means that the whole case is dependent upon 3309. There's no other issue in the case other than the fact that you didn't sign that, you said you wouldn't sign that letter, and there's no money damages for that, so case is over.
Judge,
that's your position.
I don't necessarily disagree with you because
No,
they
it's a
should never
question.
have,
It was a question. It's
yeah,
not.
they should never have surrendered the premises. They should not have surrendered the premises. They should have sought injunctive relief to have a sign. And they did that once before Judge Reed. And Judge Reed also found there are so many issues here, we can't do it at this point.
What about the fact that you let all these years go by and nothing happened?
In fact, Judge, I don't understand.
There was supposed to be constructions taking place here, wasn't there?
Yes, they were supposed to do the construction.
But you had made it not possible. You had put roadblocks.
The only roadblock we put is, we said the cure must also include these 4 other violations because it's going to come up. And the second one was, you promised us a certain amount of space after this lease expires that would be free market. Because of your malfeasance, that amount has been shortened, but it's included in the cure. In the cure, it would have not been free market.
Thank you.
All of what my adversary just spoke about is related solely to the 2015 claim. We were, prior to the repudiation, headed to trial. We were finally going to get there because Supreme Court barred them from trying to terminate the lease for a 5th time without advance permission. We were going to have a trial to determine whether these notices were proper, whether Authen had been in default in the lease, whether the tenancies affected the validity of the 2015 cure agreement. But at the time that the repudiation,
They signed that PCA, what would have happened?
we would have built the building that was contemplated by the lease, that they were obligated to cooperate with us in.
So why doesn't the whole case just depend upon the PCA?
Because we were going to, in the future, have a trial to determine whether that PCA complied with the lease, and if not, whether a new one had to be redrawn. But what happened is...
So how do you get that out of 3309 and the no damages provision?
Because the repudiation did not implicate what 3309 says. What 3309 says is, if you don't approve something, right, if you don't approve a document, the sole remedy is to get injunctive relief. But that's not what the landlord did in 2021. They said, we will not cooperate with you in effectuating this obligation. They had an obligation. Their obligation was to cooperate with us in effectuating this cure. They said, we're never going to do that. And once they said, we're never
Why
going
wasn't your remedy to go and get an injunction?
because an injunction to do what? To
Sign.
To sign. They said they'll never sign any version.
Are you saying that with regard to your breach of contract claim, that 3309 does not apply to?
Not only have we said it, the Court of Appeals has said it. The Court of Appeals said it was error to dismiss our claim for money damages, and they said that they rejected the arguments that the landlord made that for dismissal of the repudiation claim and the quiet enjoyment claim, and they argued extensively that both of those claims were barred as a matter of law by 3309. The Court of Appeals
So
says
you believe you're entitled to money damages as it relates to your repudiation claim?
yes, and the quiet enjoyment claim.
Thank you.
And
Thank you both. Rogers v. Monthill LLC. Yes.
Good afternoon, Your Honors. May it please the court. Beth Gehrig for the plaintiff appellant. Make it short and sweet. We believe that the court was incorrect in granting the defendant's motion to strike the errata sheet.
Counsel, I've never seen an errata sheet that changed substantively so many statements by the plaintiff as this one. So I'm really, is there any case law that says that an errata sheet with this number of extraordinarily substantive changes has to be approved by the motion court?
Well, I don't think there's an extraordinary number here.
Question, at any time before the accident, did you see the water that caused you to fall? This is during the deposition. Answer, no. Errata sheet answer, yes. The water had been leaking from the area under the sink for 2 weeks. Question, when did you first see the water that caused you to fall? Answer, as I was slipping. Errata sheet answer, 2 weeks earlier. Question, do you know how long the water had been dripping from the pipe? Answer, no, I don't know. Errata sheet answer, 2 weeks. Really?
Yes, Your Honor, if you allow me.
So okay, go ahead.
So first off, we're talking about 7 changes. And if you look at a number of the cases.
But there's substantive changes,
Absolutely.
right?
And
That go to the heart of very critical components of your
One question is asked and the answer is no, right? At any time before the accident, did you see the water that caused you to fall? Now this goes really to the issues, right? Mm-hmm. Answer, no. And then on the errata sheet, yes.
And the
water had been leaking from the area under the sink for 2 weeks.
And this court has allowed yes to no answers or no to yes answers take place in the past. But if I may first to address the actual questions, if you look at where his attention is being drawn, let's look at page 71 of the record. At page 71 of the record, which is the first question that is changed, he's asked, at the time of the accident, where were you looking? He said, where was I looking? Yes, straight ahead of me. The next question is, at any time before the accident, did you see that water that caused you to fall? He said no. His attention at that moment was being drawn to what happened immediately before he fell. They didn't say.
No. Okay.
They did not say to him at any time, at any date before, at any prior time, they had limited just the questions to what was happening at the time of the accident.
Right, but why was that a part of the explanation that you gave for the reason as to why you were submitting the errata sheets?
He said, I misunderstood what was being asked.
Did you explain the nature of that misunderstanding?
No, the attorney did not explain the nature of the misunderstanding. However, when they made the motion to strike, that was the time we had the opportunity to explain that, and we did. And what I'm hearing from this panel, and what I heard from my adversary, is that she doesn't believe that these are credible explanations. But issues of credibility, that goes to the jury. This court has interpreted 311.6 to say that you can make substantive changes. He made substantive changes.
No,
timely
what
and
the issue is whether in fact you've stated an adequate reason for the substantive changes.
Yes.
And here his reason being that he misunderstood has also been accepted by this court.
So how do we know that he misunderstood? Did he submit an affidavit stating that he misunderstood?
No, he submitted his errata sheet, which was all he was required to do under 311.6.
But he didn't provide on that any explanation for why he had these amazing changes in his memory. And so the appropriate time to have put in his explanation for us to credit it would have been in an affidavit in opposition to the motion, but there's no affidavit by your client.
Because it was timely, that the explanation was given timely.
But the point is there's no explanation on the errata sheet as to why the changes were made.
But if this court was accepting, I misunderstood in the Hernandez case, if this court has accepted explanations of my memory is better now than it was then, when you look at the context of how these questions are being asked and where his attention was directed, then it makes sense that he thought he was talking about at exactly that moment.
That was what he needed to put in the errata sheet so that we had an adequate basis for why these substantive changes were being
He
made.
should have stated that when the question was asked at any time before the accident, did you see the water that caused you to fall? That when he said no, he didn't understand that it meant any time. He thought it meant immediately prior to the accident.
Then what I'm hearing from this court is that.
Now, what you're hearing from this court are questions as to the sufficiency of the changes and the explanation of or lack thereof. And you'll hear more on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court, my name is Lee Tarr. I'm from Gardner and Bloom, and we represent the respondent in this matter. The standard review in this case is that if it was an abuse of the court's discretion, the court offered a 5-page decision clearly outlining that they did not find that these very substantive, completely opposite to what the answers were in the deposition transcript, were given a sufficient reason. The lower court cites this court's Figueroa case from 2024, which the appellant does not dispute in their brief, was not applicable to this matter. In that matter, the appellant stated that he was confused, and this court found that that was not enough. Similarly, in this matter, he says he didn't understand the question, which arguably would similarly be.
That was what he said as to all 7 of the items, right?
I'm sorry?
That was what he said as to all 7 items, quote, misunderstood what was asked, close quote.
Yes, that was the sole reason on all 7.
And so these were 7 questions, but there were other questions that were asked during his deposition testimony. And the questions that were asked, which confirmed his version as to negligence on the part of your client, there were no corrections as to those?
There was no, these are the only corrections, and appellants admit in their brief at page 4 that they are solely regarding notice in this matter. He understood before the accident 15 times with
But it did not go to notice.
But only on the questions when it regarded notice did he not understand the question. With respect to, I just want to address one issue in the appellant's brief. Notably, they cite this court's 1960 case, Skinny v. Silver Beach, which in fact the court said that there were 2 possible reasons to give for why to have a substantive change, and one is they're incorrect in the transcript, that the actual answer is incorrect, and that his present recollection is better and more accurate than it was before. If there's no further questions, we'll rest on our brief.
Thank you.
Your Honors, in the Figueroa case, the changes were found by the court not to be credible because what happened was he was originally saying he had no idea what caused him to fall. And then he said the plaintiff in that case was standing at the top of the stairs. He said, I have no idea what caused me to fall. And then later he turned around and he said, oh, I thought you were talking about while I was at the bottom of the stairs, not at the top of the stairs. And the court looked at the context of the questions that were asked and determined that based on the context of the questions that they were asked, his explanation made no sense. Here, based on the context of the questions that were being asked. This witness's testimony was directed to the moment of his accident. Their actual motion helps support our argument. In their motion, they say he was being asked on any day other than the day of your accident. Those words were not there. We've all done a lot of depositions.
We have a more recent case in Figueroa, one from this year, More Reason versus Manhattan College, which was similar to this, and there we reversed because they didn't strike, because they allowed the errata sheet.
Yes, except in that case, Your Honor, the reason why you struck, it was explained that it materially altered the original testimony as to the basis for the negligence. He wasn't claiming liquid on the floor. Here, at all times, the plaintiff has claimed.
Well,
the reason why-
these changes certainly seem to materially alter what he had testified to initially.
The test isn't necessarily whether they materially alter his testimony, it's whether it materially alters his claims. And I think one of the important things here is we turned around and we said, you want a further deposition of him? Absolutely, we will produce him for further deposition because you say you want to know why he did not understand those questions. So ask him why he didn't understand those
But
questions.
it's not their burden to do that.
Right,
It's
it's
your
not-
burden to then, in the first instance, provide an adequate.
And in Figueroa, again, it was without sufficient justification, which was the test. Figueroa, there was justification. As stated here, there's no justification as to why he did not understand, why he answered a certain way.
In the cases where this court has found that there is no justification, it's because there was no answer or the deponent said, this answer is correct, my other one was wrong. He is explaining he misunderstood. He's a layperson. I mean, at the end of the day, I recognize.
What about the fact that the he understood all the other questions, but only the questions that went to notice?
Which hurt him.
Which may be in opposite to his position.
No, what actually happened here is he didn't understand when his attention was being drawn away from the date of his accident to other periods of time.
But he didn't say that in explanation of why his answers were so different from what he then believed to be the truth.
He said he misunderstood.
Okay.
Thank you. Thank you both. Movimiento versus Missionero versus Sobro Development. Justice Gessner is accused on this matter. If there is a tie, another judge, Justice will be vouched.
No.
Good afternoon, Your Honors, and may it please the court. My name is Moshe Bopker. I'm an attorney at Tain, Waterman & Wortzel. We represent the defendants, appellants Sobro. This is a breach of contract case is what it boils down to, and the grant of summary judgment on claims relating to the breach of contract, rescission, attorney's fees, and accounting. There's at least 5 or 6 bases to reverse.
Counsel, the contract here was for construction of a parcel of land, right?
Correct, Your Honor.
Ground was broke on that land?
I don't believe so, Your Honor.
So nothing ever transpired
Well, I
with
think
regard to the construction?
I'm sorry. As far as we sit here today, again, but the record is really devoid of anything that's happened. I think
Well, there
What
was
did
no
you
construction
imply?
done prior to the action being commenced. We can agree to that.
I think so, Your Honor. Yes, and I think there's, again, the record, while sparse, does provide some indications, again, between the 2006 agreement and the 2015. There were issues as far as the variance goes. There's, again, that's why they had to change the scope and change the approval. And again, the record does not really give facts as to what
The contractual obligation of your client was to do construction, right?
Yes.
To build something.
Yes.
Nothing has been built during that period of time.
As far as I know, that's correct. Although, again, as far as the record is concerned, there's nothing in the record that that indicates. There's nothing in the record that indicates that it should have been commenced. That approvals, permits, etc., things like that, that were required to commence work were approved and were received. Other than
Whose obligation was it to get those approvals to begin commencing the contractual obligations of your client?
it was my clients, and in the months leading up to the commencement, they did get several things, including the variance, including the development loan, And if I may just go back to my, I guess start at the beginning if I can. The contract expressly provides that a notice of default has to be issued prior to commencement. No notice of default was submitted on summary judgment. It's a condition proceeding.
Was that argument preserved about the notice?
Sorry?
Did you preserve that argument?
That was not raised below.
Did you raise it below?
It was not raised below, Your Honor, and I recognize that. And in my brief, I do address that, and that it is on the face of the record, it's an obvious, and there is certainly case law from this court that allows this court to consider
But
arguments not raised
it's not
below.
a purely legal question, right? It also is a factual one, right?
I assume you mean as far as the notice itself?
Yes.
Yes, certainly. The notice was supposed to be written detailed. It has to provide detail, provide supporting documentation. There's nothing in the notice, which is part of the supplemental record. There's nothing in the notice as far as specifics that were and were not done.
I guess the import of that question was because there is a factual nature to that determination, it needed to be raised below to be preserved.
Well, I don't think that it needs to be raised below in order to preserve it, because I think the notice itself, the fact that it wasn't submitted to the court below, the fact that it's a condition proceeding to suit made it required to be submitted for the court to consider on summary judgment. I mean, a plaintiff could not meet its burden on summary judgment without at least alerting the court to the fact that a notice was issued, that the cure period had run, which it had not when this case was commenced, and that it had complied with the statute, with the contract's requirements for a detailed notice with supporting documentation.
But even accepting that, so you have a 30-day cure period, but you never broke ground. You never began construction.
Well, I think that, there were
During
steps.
how long a period of time? 2 years?
I'm sorry?
During the 2 to 3 year period, I think it's 2 years, right? You never broke ground, but you're stating now that there should have been a 30-day notice to cure. You're going to break ground and start and construct the building during that 30 days?
Right. Well, I don't think the 30-day cure period was specific to breaking ground. I think it was to moving, again, the project along. There were other requirements.
I mean, let's be clear, right? The contract started 13 years ago.
The original contract was in 2006, correct.
right.
And I think the fact that
And there was an amendment sometime after.
there was an amendment, I think, again, that period of time, I think it's clear that period of time, they couldn't get the variance. The project could not be completed as anticipated. And so they were forced to essentially revise the project, change plans and scopes and things like that.
Right, so I was giving you from 2015, when there was an amendment, I was giving you from 2015 to 2019, I guess, right? Or 2020.
Yeah, the action was commenced in July of
2019. So I was giving you actually 4 years wherein there was no construction done whatsoever.
I understand, Your Honor. And again, I recognize that, and the record below does not give any explanation, again, other than the conclusory assertion that, hey, nothing was done. There's no specificity as far as what was supposed to be done, what hadn't been done. There was conversations, I would say conversations, there were letters back and forth, which are part of the supplemental record, where there's obviously a dispute between the parties about what could be done, what couldn't be done, why there was a delay. And again, the court below was not apprised of of this back and forth, let alone the notice of default itself, which
Yeah,
again
because
was
you didn't
required.
raise that below, right? You didn't raise that argument before the trial court.
We didn't raise it, that's correct, but it wasn't our burden on summary judgment to prove compliance with the contract. It was plaintiff's burden as the movement to prove that it had complied with the contract and that we had breached it. And again, as the notice of default was a condition proceeding to suit, it was required to be submitted to the court. The court below could not have assessed the sufficiency of the notice, the fact that the cure period had not run, without being submitted on summary judgment. I mean, it's a part and parcel of the case is to prove the elements of the case.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court. Jeffrey Mazes, Movimento. Counsel points out that there was a contract, which there was, and there are important parts of that contract. There's 2 parts to it: notice and the opportunity to cure if you're given that notice. Notice was given below, even though counsel clearly did not raise it. In the record, page 211, paragraph 19, in the plaintiff's notice verified complaint, there's mention to that letter. In the supplemental record, page 1, there's the letter that was sent to counsel stating you're in default, and let's try and fix this. And unlike what counsel just said, that letter that counsel wrote in response to that is just saying, we don't agree with what you said. Not saying we never received no response. Not saying that, no, this says,
their July 10th letter that in response to your letter?
correct. That's not saying that we didn't receive the letter. It's just saying we don't agree with the letter. So it's very contrary to what counsel's arguing here today. And the fact that they never received the letter per the contract, they did. They responded to it. They just didn't like what it said. And then in their verified answer on page 237 of the record, paragraph 19, they admit that a document does exist, which is SR 5 that we just spoke about, the July 10th letter. In addition to that, assuming that they did work diligently to try and cure this, they clearly didn't. There was over 15 years since 2006 that nothing happened. And
That's why they argue that discovery is necessary in order to determine what was done and what was not, and what could not be accomplished during that period.
But then again, they never specify what they were missing. We have the 2015 amended SDA, which gave them the opportunity to go back and get the variance, they said, to do other things. And in return, all they simply did was burn the property with 2 mortgages worth over $6 million. And there's another action going on with that because they defaulted on that. They haven't built anything since then. There's no movement at all, and there's been no construction, and all they've been doing is just trying to hold up this project.
And regarding the discovery of what was the impediment to them getting the variances, that is within their control, right?
Correct. But at the same time, if they had a problem, they should have brought it up, and they could have specified, hey, here's what we're missing. They never said that. All they're simply saying today is, hey, you have section 9.2 of our contract on the record, page 62. That's what they're referring to. And they're just saying that you're in violation of that, which we clearly were not.
What about the statute of limitations claim? I started it at 2015, which was the amendment. They're stating that you're beyond the statute of limitations, that it's prior to 2015.
It's not. In 2015, the contract changed. They agreed to it, and they got the amendment. It was a big difference in the contract where you went ahead and they have all these different changes. You have the variance changes. You have a difference in the scope of the work. Building, and they're trying to make the amount of units smaller than the initial design. And that changes the whole thing. So the statute of limitations started in 2015. We're clear within that time, starting in 2020, which is 6 years for a contract.
You're not also suing based upon the 2006?
Sorry, Counsel?
You're not also suing based upon the 2006 agreement?
Now, the 2015 one incorporates the 2006, but we're suing based on the 2015 one right now, which does not have any provision that really states you have to give any notice of a default, but we're incorporating the 2006 one. We gave notice, and that's why we're arguing about that point. And then in terms of rescission of the contract, clearly the crux of this contract was destroyed. No building was ever built. No church was ever built. No apartments were ever built. Mortgages were encumbered on this property, and the only one that's getting hurt is the church at this point.
Do we know what the money from those mortgages were used for?
They stole it, and we don't know what they did with it. It's just gone. They claim that they're finding new people, and it's went in the thin air.
Thank you.
Thank you.
If I may just briefly respond, paragraph 19 of the complaint. So the complaint is not verified. It can't act as an affidavit on summary judgment. Paragraph 19 of the answer expressly denied, the allegations in the notice to cure. I don't think there was the claim was not that it was never served. It was never submitted to the court below, which was required. And there was no judicial admission at any point that the notice was sufficient, that it was served timely, and 30 days and longer if they started to cure had been given. As far as rescission, I think it's clear, the case law is clear that contract can't be rescinded. The rescission is not proper if the contract's not time of the essence, and this all we've heard is delay. Delay itself does not make it time of the essence, does not make rescission proper. And more importantly, rescission requires that the parties be able to be restored to the status quo ante, and the court below specifically noted in its decision that the parties could not be restored to their status quo prior to the the agreement. So rescission is improper for both those reasons.
Because of those mortgages that were taken out, correct?
Well, they were, in part, but yes, when mortgages were taken out as part of they were anticipated by the agreement. These were not mortgages that we decided unilaterally that we needed. This was part of, again, there had to be funding. My client is it's a not-for-profit company. It's not here to, it's not using its own funds
To use it, the purpose was to build something. That
Correct.
was the purpose of the mortgage.
That is certainly correct,
But
Your Honor.
none of that money was used to build anything because nothing has been built.
Not to date. That's correct. I mean, again, some of it was for to go through the variance process and things like that. But certainly, I recognize that it's the extent of it was for the building the project.
Thank you. Thank you both.
Thank you.
First Trinity versus advanced funding.
May it please the court, Stephen
just
Wegg.
1 second.
Sorry.
Okay, thank you.
Stephen Wegg on behalf of the appellants. The first leg of the appeal has to do with the personal jurisdiction issue, being that the defendant, Monica Ray, has lived in Florida for decades at this
But
point.
did business here, right?
I'm sorry?
Did business in New York.
She did not do she did business only from Florida.
Right, but no, go ahead, sorry.
Her emails were signed with an address from New York City, and she did business regarding matters in New York City. Why wouldn't she expect to be sued in New York?
Well, her emails had address in Jupiter, Florida, and also that other New York address. But the issue with that is that she was working. The law is quite clear that an employee working within her official capacity, even if it's a New York company or the company is doing business in New York, she has to be acting outside of that official corporate capacity as an employee.
If she committed a tort,
I'm sorry?
if she committed a tort, if she's behind the fraud that's alleged here, then the fact that she's in a corporate capacity isn't going to protect her, will it?
Well, Your Honor, that's actually a different section of long-arm jurisdiction that the plaintiff isn't relying on. The plaintiff is relying on CPLR 302A1. That would be in CPLR 302A3.
No, but he's talking about her status as an employee. If she behaves in an ultra-virus way, that does not protect her if she's acting as an employee, right? She's part of the fraud. It's not that the tort was committed without the state, not that provision of the long arm, rather that she just loses her protection from status.
Because you were pointing to the fact that she's just an employee as protecting her.
Well, that would be, I think, for a corporate officer, not necessarily for an employee.
Is she a lawyer?
No.
How do you get to be head of the legal department, not the lawyer?
Your Honor, I wasn't there at the time, but she's a certified legal assistant in Florida, which is, I think, the equivalent of a paralegal.
Right.
And just because she
Probably
handled,
doesn't matter.
she handled the communications involving the legal matters because it's to approve lotteries.
There are a lot of New York angles to this. Where does Martinez reside?
Martinez, I believe, resides in New York, but she had never
Which
had any
state's
interaction
lottery
with him.
was it?
I'm sorry?
Which state's lottery was it?
It was a New York lottery. But she never had anything.
And where's Advanced Funding doing business?
Advanced Funding is not doing business. I don't. They're a New York corporation.
Allegedly.
They were a New York corporation. I don't know if they were actually functioning.
Where's Trinity doing business?
Trinity's in Oklahoma.
Where was it doing business?
Trinity in Oklahoma.
I'm sorry?
Trinity in Oklahoma. In other words,
But
if the
it acquired
communications,
this in New York, didn't it?
the communications between Trinity in Oklahoma and Ms. Ray in Florida were the crux of what's being alleged.
Right, but the subject matter of what they were talking about was a lottery ticket that was won in New York, right?
Well, that was a separate transaction. In other words, Advance purchased that from Martinez, and then Advance
No, we
was going
understand
to
that,
assign.
but the issue is that the ties to New York. So you see, you have these various ties to New York.
All roads lead to New York.
Right.
Understood, Your Honor. If I
You
could just
can't really be very surprised. I mean, Ray can't be very surprised that she ends up in New York Supreme Court.
If I could just jump to the more factual issues, the actual causes of action, the unjust enrichment and the fraud. The unjust enrichment, as we argue, is barred because there's a written contract.
Well, let's talk about the fraud.
I'm sorry, okay.
Talk about the fraud.
We can talk about the fraud. The main issue with the fraud is that it's clear that Ms. Ray was used as a pawn by somebody who allegedly was committing a fraud. She had no idea. The record is,
That's not clear at all from the record. I think it's quite possible, I mean, possible she was a pawn. It's possible that she was a principal.
well, the only evidence that's actually in the record is her denial of having any knowledge and her asking Dan Savalos for all the information that she needs.
She also engaged, she was the person who sent the, what turned
copy
out
of
to
the
be a
check.
false.
The fraudulent wire
Fraudulent
transfer.
wire.
Right.
The emails regarding the fraudulent check,
A copy of the check that was allegedly issued to the winner and the wire transfer.
and
She
all
swore
of the
by the truth of
fraudulent assurances that this money had been paid.
And she went so far as to say that Mr. Martinez had been overfunded, I think like $10,000. Yeah, $10,000.
Well, that was just a matter of math. But
And where did she get the wire transfer?
so it's in the record that she received it from Dan Savalos. She has the email to him that says, "I need proof of the wire," and that's where she got it from.
So
So
again, are these not all issues of fact?
they're not issues of fact because there's nothing from the plaintiff that
What?
proves anything contrary to what's
Yeah, but you, it was your motion, right?
correct.
You had the burden of showing.
We can't prove a negative, and what she did was she submitted her testimony showing that there was no knowledge on her
You can't
part.
prove a
and that she was
negative,
pawn.
but a lot of money was stolen here, or attempted to be stolen.
And I think, don't we have something from Martinez saying that he never received the monies?
Well, he had a lawsuit he said he never received some of the monies. Not that he
Right.
didn't receive
He
all.
unraveled this, didn't he? So that
Right, he
supports that
unraveled
didn't
it, yeah,
receive the
that was
money.
the other
He unraveled some of it, from what I
So
understand.
that
not all of
supports
it.
that he didn't receive the money.
Right.
Right, but there's also the reliance issue on Trinity, and that they did absolutely no diligence on their own. A $300 million insurance company.
There were all these emails requesting information. How is that not doing diligence?
Because they didn't confirm anything. All they,
Because she
Received
sent
the
the wi- she sent it-
confirmation. She
yeah,
received
well, nobody
You have
called.
time on rebuttal.
Thank you, Your Honor.
Good afternoon, may it please the court. My name's Danielle Marlowe, and we represent the plaintiff and respondent, Trinity Life Insurance Company.
So when you get this wire transfer, did you have to do more due diligence to see that it's legitimate?
I believe that there was a follow-up correspondence where Starla Williams went back and said, well, was he paid? And they took a look at all the different, there was a whole closing binder. So yes, there was inspection as to whether it matched the information from Mr. Martinez. Did they have to go to the actual bank and verify? I think that was beyond a
Well, was there
reasonable
anything
inquiry.
that would lead them to believe that it was a fraudulent transfer or that the copy of the check was inaccurate?
No, Your Honor, because as Ms. Ray actually admits herself in her affirmation or affidavits, these parties had conducted hundreds of transactions, or she had conducted hundreds of transactions, and Trinity and Advance Funding had conducted a number of transactions. And there's actually a case that we cite, I believe it is Knight. The Knight case, where it talks about if parties have engaged in a number of transactions, reliance is reasonable because there's been a pattern of transactions, and there's not a reason to doubt the veracity of representations. Knight Securities versus Fiduciary Trust, 5AD 3rd 172.
Counsel, regarding the reliance, this closing binder had a considerable amount of information in conjunction with this fraudulent wire transfer that was purportedly proving that the money was paid, right? It had proof of payment of filing fee, certificate of term payment, lottery assignment agreement. It included a lot of documents, correct?
Correct, and that led our client, Trinity, to believe that there was a basis that he was paid, that there was his on the up and up, and there were W-2s, identification documents. There was just no reason to doubt that there was anything untoward here.
And then they even go back and forth discussing his divorce decree, right? To make
Yes.
sure that there weren't any issues from that angle.
Correct. The divorce was in Spanish, and Trinity went back and asked for additional information. I mean, I believe if you look at the email chain, it starts like, let's say December, about 3 or 4 days before, and there's back and forth between Starla Williams, who is a person from Trinity, and Ms. Ray, where she is asked, Starla Williams is asking for additional information. And then she even says, after she received, Starla receives the check and the wire, she said, so has he been fully funded? And then, as your honors noted, Ms. Ray doesn't just say yes, she says he's been overfunded, which gives every indication that Ms. Ray knows what the amounts are and actually went back and vetted it because she says he was overpaid.
And she doubled down on that by saying, we're even trying to get back some of that money we overfunded him by.
Correct, Your Honor. And yeah, as far as the some of the other points with regard to personal jurisdiction, the idea that she was just functioning as an employee is contrary to the fiduciary shield doctrine, which has been, or is an argument pursuant to the fiduciary shield doctrine, which has been rejected pursuant to the Croyder v. McFadden oil case. And with regard to the argument that she's not an officer, first of all, as your honors have noted, that's an issue of fact. Second of all, it says right on her email signature, director of the legal department, and she functioned. The reason that she was sued by our client is she was the only one they dealt with.
Right. She was the one who engaged in all the transactions. No one else from Advance engaged in any of these transactions.
Correct. And as we note in our paper, she speaks like, we can offer this. I can do that. But you don't do that if you're just a low-level employee. She's speaking for Advance funding. So she's functioning as an officer. She has an officer designation in her signature line. So at best, I mean, we think it's conclusive that she's an officer, but at best, it's an issue of fact.
Thank you.
Thank you.
In 1995, this court issued a decision called Stewart-Lipsky PC versus Price, and what that case holds is that a party cannot claim reasonable reliance when it chooses to rely solely upon representation without any effort to verify that information. In this case, there were no reps and warranties. There was no attempt by Trinity to go and to check any of the information. All they did was they took information from Ms. Ray that she received from the people at Advance and relied on it.
There is always the context of the commerce that we're dealing with. You don't think you can rely on a copy of the wire transfer when it's furnished to you by Ms. Ray?
I think
you think that you had to go behind that?
I think that they should have at least called Martinez and said, hey, Mr. Martinez, is it true that you assigned this and that you received the money? That would have been the first call.
They had an affidavit and a closing binder from him, purportedly from him.
Right, and Stewart-Lipsky talks about reasonable reliance without any effort to verify the information. We have the back and forth with Advance and with Ms. Ray. We have the closing binder. We have questions. They ask questions, the divorce, etc. So, I mean, I think it's a little different from Stewart-Lipsky.
Well,
They even asked for written confirmation, which was done.
Well, they didn't go outside of Ms. Ray in any way.
She was the one that they were dealing with. Should they have said, we want to speak to a supervisor? Why? And she appeared to be the supervisor, which is another question. But should they have said, oh, we want to speak to someone else? Why would they do that? And why would they have an obligation to do that?
Not that they should have asked to speak to a supervisor, but that they should have spoken to Mr. Martinez. They should have been able to verify that this transaction actually happened.
She having furnished these documents, why should she escape liability? I mean, I understand whether you can get to her personally or not, but I mean, there's nothing here which says that Ms. Ray can say, oh, I'm not responsible for any of this. She's the one who furnished the documents. Maybe if her defense is, well, I'm just an employee and that's established, maybe she gets out of it. But in terms of the allegations, in terms of summary judgment, she's an active participant in accomplishing this fraud.
Thank you. Thank you both.
Thank you.
Allegedly.
Allegedly. People v. Darren Bailey. Yes, you may proceed.
Good afternoon, Your Honors, and may it please the court, Alexandra Mitter for Appellant Darian Bailey. This is an indefensible decision, and respondent doesn't actually defend it. The motion court applied an outdated version of CPL 44010 to deny Mr. Bailey's claims as procedurally barred. Respondents conceded that was error. We're now reaching into the court's alternative assessment of the merits arguments. And even then, respondents not defending the particular rationale of the motion court. They've offered their own different reasons for affirmance, presumably ones that they thought were on less shaky ground than the ones offered in the motion court's decision below. There's no question that counsel did not investigate Mr. Bailey's mental health issues. The question is,
Would it have been helpful? I mean, of course, a question that's raised is, would it have been helpful to him?
Your
Because
Honor,
the psych history was, about him malingering and other things. It didn't seem so helpful anyway at first blush.
two answers to that question, Your Honor. First of all, there are real diagnoses with real prescriptions for antipsychotic medications, mood disorder, depression medication. So I think worst case scenario, we're talking about some disagreement between medical professionals about the scope of Mr. Bailey's mental health issues, but that's really kind of putting the cart before the horse.
What I did not understand is what would it have gone to in terms of the act itself? There's a video of it, right?
There's not a video of this.
There's testimony as to what occurred. He admits to what occurred. Afterwards, there are two other witnesses, right, who are present. And I think the corrections officer was present as well at some point in time.
Yes, Your Honor, the correction.
And the defendant admits to, in that he says, "I'm sorry," right? So I'm not really clear. He doesn't at any point say that he didn't understand what was going on or that he was having hallucinations or anything like that. So how would this have even been admissible at trial?
Well, what the corrections officer describes as seeing Mr. Bailey sort of pacing back and forth, mumbling it to himself. Yes, some of those words included, "I'm sorry," but Mr. Bailey's behavior was such that they thought he was having a psychotic break and sent him to the hospital. So it goes precisely to what was happening in his head at the time. And again, going back to the previous question from Justice Moulton, it's putting the cart before the horse here, because in the Court of Appeals decision from Olivares, they made it quite clear that a decision born in the blind, if you haven't looked at those medical records, if you haven't looked at whatever records we're talking about because you didn't do the investigation, you can't decide as an attorney what is the appropriate strategy to pursue. And I think it's really important to look at the facts of Olivares, because there—
Well, Olivares was a 7:30, failure, I think, to move for a 7:30. He moved for a 7:30, was found fit, but despite the observations about Olivares' impairments, I think the defense attorney never consulted with an expert or obtained other expert testimony.
And he didn't request the records, which the dissent in Olivares described as worse
So
than useless.
where does Damien's letter figure into this, in which he says that he does not recall any mental health issues interfering in any of our communications or affecting defendant's ability to assist in his own defense? And Damien doesn't remember either defendant or prior defense counsel ever bringing up defendant's mental health.
And Damien was his defense attorney.
Was his trial counsel, yes.
That's who you say was ineffective.
Correct, and who provided that in an unsworn letter addressed to the prosecutor after he refused to speak with Mr. Bailey's appellate counsel. And so as an evidentiary matter at a 440 stage, it's worse than useless, not to take the dissent's language from Olivares there. It has no evidentiary value. It's not sworn. At worst case, I think it would behoove this court to have a remand for a hearing so that Mr. Damien could actually answer those questions under oath. But more to the point, the idea, it just completely perverts the relationship between a defense counsel and their client. It's not on the defendant, particularly where we're talking about the sort of sensitive issues of mental health, to be sort of spoon-feeding the case to his attorney. It's on the attorney to do the inquiry, the minimal inquiry, that would reveal avenues of investigation.
Yeah, but what if the attorney takes the view that the psychiatrists say, well, he's malingering?
Your Honor, he couldn't have taken that because he didn't have these records, and that's exactly what happened in Olivares. You can't make that decision if you haven't looked at the records, and the records in Olivares were far less helpful than what we're talking about here. But the fact of not
Did
doing
anything
that.
transpire in open court which gave you reason to think that he was not mentally competent?
Absolutely. I mean, the facts of this case, it occurred in a part of central booking that is reserved for people with physical and mental health issues. And so, sure, maybe he was there with a physical issue, but if you don't ask your client that question, you can't preclude that avenue of defense.
No, but there was a jury trial here, right? Do you point to anything in the record during the course of the trial that raises issues about his competency?
Yes, there was testimony by the corrections officer that Mr. Bailey seemed very emotionally unstable.
Now, during the trial, were there any outbursts? Was he, you know, speaking, talking to himself, anything of that nature?
Not that I'm aware of, Your Honor, but I think that's, again, respondent points out the fact that counsel said Mr. Bailey was sort of respectful in their interactions, as if respect and mental health issues are mutually exclusive.
No, there has to be, the point is, was there anything which would give rise to the attorney believing that the defendant was suffering from some type of mental disease or had some type of mental issue?
Yes, I think all of the facts of this case, including where it took place.
So you're pointing to the fact that in August of 2014, the defendant seems upset or emotional after this occurs, right? After the incident that he's convicted of takes place.
Yes.
And the trial actually takes place sometime late 2015, because it ends in a sentence in December 23rd, 2015, so probably something like November. So more than a year later, you don't point to anything over this period of time which places his competency in issue.
It's not about him being competent at the time of trial, Your Honor. It's about his mental status at the time he was alleged to have committed this offense. And there's lots in the record that had counsel taken the time to look at it and talk to Mr. Bailey would have revealed mental health issues at that time. And that's
Because he was very emotional after the attack.
And was subsequently, both before and after this incident, in and out of psychiatric care. And for what it's worth, I take your point about his conduct at trial, but since he was upstate after this conviction, he ultimately received a 1-esque diagnosis, which is the absolute highest level of mental health designation that New York State Docs offers.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Juliana Susu for the people. Just to start, we are not conceding anything. We are not conceding reversal, especially. The motion court denied defendant's 440 motion under CPL 440-10-1H, finding that defendant received effective assistance of counsel.
Your friend said that the court considered 440 under the wrong under an outdated statute and applied a wrong standard. Could you address that?
Under two different statutes, 440-10-2C, which does not include ineffective assistance of counsel, and then also under 2A, which is if the merits of that claim were made down below and nothing new has been brought up before the motion court, then the court can deny that on procedural grounds. But in addition to the procedural grounds, the motion court also denied defendant's ineffective assistance of counsel claims on the merits, finding that he received effective assistance of counsel. He didn't have to discuss in substance every single claim to have made that decision. Regarding the psychiatric history, counsel was not ineffective for not looking into defendant's mental health history. There was none of the interactions that counsel had with defendant indicated that defendant had a mental health psychotic issues, None of the evidence counsel received prior to trial indicated that defendant had mental health issues, and the facts and circumstances of the assault did not indicate a possible psychiatric defense.
What about the defendant's behavior after the assault and in terms of pacing up and down, and also the defendant receiving psychiatric treatment after the incident?
So the pacing up and down, it was clear that he understood the wrongfulness of his conduct, saying sorry for hitting him, and was clearly just upset for what he did. It didn't really indicate that defendant had a mental illness, and especially since the day, just less than a day prior to the assault, defendant was psychiatrically cleared, indicating that he did not have a mental illness. So no information in the
And the psychiatric treatment after the incident? Was in between the incident and trial?
Yes, the defendant received a psychiatric evaluation, I believe, as the sergeant indicated in his testimony. That was protocol under those circumstances, but that alone would not have prompted counsel to look into a psychiatric defense, again, given that the evidence of the case did not indicate that this was the result of mental illness. And even had counsel looked into those medical records and presented that, that would have done nothing to benefit defendant, as Your Honor's pointed out. The overall consensus among the multiple doctors that evaluated defendant over a period of time was that he was malingering his symptoms, and that his behavior was done in an effort to prolong the arrest process and avoid going to jail. So it would have done nothing to benefit defendant's case at trial or at sentencing.
Right, is there any showing that these alleged deficiencies would in any way impact the outcome of the trial?
No, Your Honor, it would not have, because again, there was no indication that defendant even had a mental illness, particularly immediately after the assault happened. The doctors concluded that he did not have hallucinations, that he was faking that he did not have psychosis, he was not intoxicated. So nothing that would have indicated defendant did not have the mental culpability at the time of the offense. Just briefly about the Brady issue. The court correctly found defendant's Brady claim was procedurally barred, and also, regardless, there was no Brady violation because defendant fails to identify any persuasive evidence of the existence of this form and what the form would have stated, much less exculpatory evidence. And without any evidence that the form actually exists and what it stated, defendant cannot say that the people suppressed exculpatory evidence from defendant. In any event, a defendant would not have been prejudiced. The form likely would not have included anything relevant for defendant's defense. If there are no further questions, we ask that you affirm. Thank you.
I think respondent takes a pretty dim view of how defense counsel should be interacting with their clients and looking at a case. Sure, we might be able to offer a variety of other non-psychological reasons that Mr. Bailey was pacing back and forth and ultimately sent to the hospital for psychiatric evaluation. And sure, maybe he had got an injury, and so that's why he was in this special area of central booking and not because he was previously needed to be evaluated by a psychiatrist. The fact that we can come up with these other reasons, A, is not what counsel offered, and B, doesn't obviate counsel of the obligation to investigate those in the first place. Being a defense attorney is an important job, and I'm not saying that just because that's my job too. He was being trusted with determining what the best course for Mr. Bailey's defense was.
That he was ineffective because he did not obtain these records.
I am saying that is absolutely ineffective assistance of counsel, yes.
Because he did not obtain the records.
Correct. Because you can't evaluate what the best course of defense is if you don't have the information in front of you to make that decision. And how it may have come in at trial or at sentencing, for example, where the court found there was no mitigation whatsoever to be offered.
Well, he did speak to probation, right? And I believe when he spoke to probation, he stated that he had no history of any mental issues, that he had not been abused, I think, as a child, and there were no issues with
And it would have been really nice if defense counsel had done that investigation to give the actual story, the real story, and maybe explain.
That wasn't the real story. What did he tell probation?
It's impossible for us to say on this record because counsel didn't do the work required to advocate for his client.
Thank you. Thank you so much.